Hi, Asha. Thank you for waiting in the waiting room. We will commence shortly. Commissioner Chair.
Okay, thank you very much. Good morning, everybody. Welcome to the first of many hearings on the District Plan Review for Central Hawke's Bay District. We were welcomed by Mana Whenua this morning, and they wished us well on our hearing process. And we are bequeath this kete as a symbol for our deliberations and our thinking ahead and our mahi. Because we're doing this in a hybrid form, the usual etiquette applies to the hearing here. These are informal hearings, and that means there's no cross-examination by any parties. The panel asks the questions. We try and keep it fairly informal other than that. In the actual room here, hopefully everyone's got their phone on silent or something similar, just to stop that from happening. Online, if you are speaking, we would like to see your face if possible, if your bandwidth allows it. So please put on your camera when you are talking to the panel. That would be much appreciated. The other thing too is we have just disabled the comments box because we have found, well,
Sorry.
That's all right. In the past, that people can use their comments to sort of interrupt people speaking, so that's been disabled. Now, the agenda for today, as usual, hearings are a flexible beast, and we're probably likely to make changes. But prior to lunch at 12, we are having a legal overview to just give some guidance to the panel and to submitters as well around the sort of legal framework ahead of us for these hearings, not just confined to hearing number one, but for all of the hearings. So we will have some questions, no doubt, around that. At lunchtime is 12 to 1, and then after lunch, we will have the Section 42A report authors talk to the panel, just provide any summary of the key points and findings and any sort of changes in thoughts or recommendations since those reports were circulated. Now, we due now, hopefully, to have our first submitter, Fire and Emergency New Zealand, come online at 1:55 p.m. We've tried to give a bit more time for the 42A report for questions. Dr. Lelivre at 2:15 with a 2-minute break at 2:35, and then we will have Jet Boating New Zealand, 50 water security project, sorry, and Kurt and Tricia Zant at 3:35 p.m. If we run out of time in terms of the Section 42A report writers, we have set aside time after the Zants, so just after 4, to sort of turn back to the Section 42A report writers and continue questions. And that's today's agenda. Thank you. Other points? So the panel before us, I know actually you will be very familiar with, but on the panel today we have Kate Taylor at my far left, Loretta Lovell to my immediate left, to my immediate right, Dr. Roger Marker, and to his right, Pip Byrne, and to her right, Tim Aitken. So they're the panel. There's a full panel to hear stream number 1. So I think without further ado, I might just turn to Asha. Asha Davidson, can you hear us all right?
Yes, I can, thanks. Hopefully you can hear me.
We all hear her? Okay, thank you.
I'll try not to block the microphone. Good morning, Mr. Chair and panel members. Nice to see you all in person. Sorry, I couldn't be there physically, and hopefully I'm not looming over you too large. It's always my fear with these screens. So at the request of the council, obviously I'm the legal counsel for Central Hawke's Bay District Council as the proponent of the proposed district plan. The officers have asked me to set out some general principles that will guide the panel's consideration of the submissions as we run through the 7 hearing streams that are currently scheduled. At this stage, I appreciate that a lot of the principles are likely to be relatively in the abstract rather than having specific examples. So I will just run through it fairly quickly. It's as much a resource for you to refer back to as issues come up where these types of things arise in practice that they're likely to arise. So unless you particularly would like me to read through it word by word, I was just going to sort of run through and give you the highlights. I don't think anyone wants to hear section 32 read out to them if we can avoid it. But
we have all read your very informative and instructive submissions. So if you would just like to highlight your key.
Okay, I'll just whip through them and feel free to stop me, or I can take questions at the end, whatever is most convenient to you. I've just noted at paragraph 4 that I have sought to provide cases where I've referred to them. Again, obviously they won't be, I don't expect anyone to read them at all, but if issues do come up where you think that one of the cases that I've referred to might be helpful, they're available for you. At least I hope they are. I have tried to link them, but if there's any issue, then obviously just let Jessie know and I can fix that up. So I probably won't run through the overview of the proposed district plan process. You'll be familiar with that background and the fact that we are now dealing with over 2,500 submission points. And those have been broken up into various hearing streams, and within that several subtopics which will be addressed through separate hearing reports. We are aiming to have those available to the panel and to submitters approximately 4 weeks before each hearing, with expert evidence from the submitters being due 2 weeks before that. Just to let you know, I mean, obviously that staggered process is really helpful, and for today's or this week's hearing, we've managed last week to address one submitter's issue altogether so that they're no longer intending to be heard. That was through Ms. Morgan reading the evidence for Horticulture New Zealand, preparing, sort of being persuaded by her and seeking to change her recommendation. That was shared with Ms. Landers last week, and as a result she's indicated she agrees with Ms. Morgan's revised recommendation, no longer wishes to appear. So Ms. Morgan can address you on that, but that's the kind of process that we're trying to limit your focus to the meaty issues, I guess, rather than the technical ones that can be sorted out between them. Obviously, you'll still need to be satisfied that you're happy with the wording, but at least you don't need to hear evidence on that. So I've just noted there, as you said, Mr. Chair, it's relatively informal, and with the number of points we're dealing with, there is some potential for some to slip between the cracks. I don't think any have been noticed so far, but we're certainly alert to that possibility. So we will just keep you updated if and when anything needs to be mocked up towards the end of the hearing process. So I've said there that your delegated task is to hear submissions on the proposed district plan as well as requirements for designation, and then you'll be required to make recommendations to the council and support. You will, as I'll come to later, you'll support those with an assessment under section 32AA if there are any changes from what's been notified. That's all pretty self-explanatory, but I've just noted there that obviously for requirements for designation, they're quite a separate beast. So the intention is that if it would be helpful to the panel, we can present separate legal submissions on the various tests that apply to requirements for designation at the relevant hearing stream, which I think is right at the end at hearing stream 7. So in terms of the legal framework, again, I'm not going to take you through the long test at Long Bay amended by Colonial Vineyard, nor the Edens and Thames District Council one. I've set those out for you there, and I always find it sometimes just helpful when you're writing decisions to go back and look at how the court has set out that test as a way to think about the relief you're being asked to consider. Section 32 is obviously an important part of that test. Again, I've said to you that the reporting officers will endeavour to apply the relevant tests as they consider submissions, and that will be a useful resource to the commissioners, to the panel as you go through. And I think I've suggested later that it can be quite a useful thing to bear in mind when you're asking submitters or witnesses questions, to give you the material to populate your decision and your 32AA analysis in due course. So I've set out there, I'll just whip through it briefly, the requirement for section 32, that there is a requirement to consider reasonably practicable options for achieving objectives and the efficiency and effectiveness of the provisions in achieving those objectives. And that needs to be done to a level of detail that corresponds to the scale and significance of the environmental, economic, social and cultural effects that are anticipated from the implementation of the proposal. Again, that's just a repeat at paragraph 22 of the statement in section 32 about assessing benefits and costs and considering where you can the economic growth and employment that are likely to be generated by any particular provisions. And the risk of acting or not acting can become quite important in some circumstances as well. Now, I've just noted there that you don't need to look at every objective in isolation, and in fact, generally they have been designed to fit together. I'm not sure if the coastal environment example that I've given you is the best one, but I wanted to pick something that was in front of you today as opposed to further down the track. So I've just noted that the objective that looks at protection of the natural character of the coastal environment sits alongside an objective that provides for activity with a functional need to locate in the coastal environment. And obviously those two objectives need to fit together to, in a sense, different sides of the same coin. So that's an example of assessing objectives holistically rather than on an individual basis. So at paragraph 24, I've just set out, I guess, some definitions that have come through either in case law or in the Ministry for the Environment's guide to interpreting section 32, and I have provided a link to that guide for you if at any stage it's relevant. Unless you think it's particularly helpful, I think I'll just take those definitions as read at this stage. As I say, it may be useful to come back to it if someone puts to you an argument that just doesn't quite ring right, or you want to refresh your memory about what efficiency means and that sort of thing. And I've just noted at paragraph 25 that if issues do come up that raise quite complex issues about any of those issues, such as, you know, what is a cost, how do we weigh that against benefits, then I'm happy to present further legal submissions. And of course, submitters are entitled to present legal submissions on their own behalf as well. So returning to the section 32AA report, that has to be pretty much handed up at the same time as your recommended decisions when they go to the council, and the council is required to have particular regard to that assessment when it makes its decision as to the final content of the proposed district plan. And I've just said there that the officers will include Section 32AA to support their recommended changes, if any, when they present their reports. And at 2028 there, I've just noted that I believe it may have been signalled in the minute 4 or minute 5 that submitters are invited to particularly address how the relief sought addresses the statutory tests, and those are, it may be useful to bear those tests in mind as you're questioning submitters or witnesses. So I've spent a bit of time on the King Salmon decision, and I know that has been raised in some of the evidence that's been given in relation to this hearing stream. So it may require some further thought or application to the particular issue as part of the council's reply. But I've just given you the reference for it there. Again, that this is one that I wouldn't necessarily recommend you read unless you need a good sedative, but it is there for you, and I've tried to draw out the principles of it, as obviously it's been considered in numerous cases since then. So and I appreciate that the panel members will probably be quite familiar with this, so feel free to tell me to speed it up. But I think this did change the way that plans are prepared and considered from the last sort of round of plan reviews that at least I've been involved in. So it has become quite important. And that is that we always used to undertake a sort of part 2 assessment for everything, and that was an overall balancing type exercise where you'd look at section 5, 6, 7 and 8 and assess it generally against that. So what the Supreme Court did in King Salmon was essentially hold that where a higher order statutory planning document has already interpreted what is required by part 2, and if your planning document is required to give effect to that higher planning document, then that's where you stop. You don't need to go higher up the chain to part 2 and essentially reinvent the wheel because that process has already been done. So in King Salmon, the issue was the New Zealand Coastal Policy Statement, and this will be relevant for you today in the Coastal Environment section. That the NZCPS already addresses what the requirements of part 2 are for coastal resources and has set those out in a series of policies. So as a result, when you're considering objectives and policies and rules for the coastal environment section of the PDP, you don't need to, and in fact shouldn't, go to part 2 to consider what's required, but you should really only go to the New Zealand Coastal Policy Statement. So the Supreme Court held that that approach applies absent invalidity, incomplete coverage or uncertainty of meaning in the relevant higher order statutory documents. So if it's the case that though one of those caveats apply, then yes, you may need to go to part 2. And I think that's important here because I was going to say unfortunately, but it's just how it is. The Hawke's Bay Regional Policy Statement was prepared some time ago and prior to King Salmon. And so I think that we need to be quite careful in expecting the RPS to have all the answers in this case. And I've said there it's probably comes under the incomplete coverage caveat. And that's because plans that were prepared before King Salmon, I guess, were produced under a different lens than we now apply. And the language that has been used in those earlier planning documents may not have been as careful as it now needs to be. And I guess that's the second major implication of King Salmon, which is that essentially where a planning instrument uses a word, then that is to be applied as it's worded, and not no gloss applied to that. So in King Salmon, in the New Zealand Coastal Policy Statement, the policy that they were looking at used the quite directive terminology of requiring adverse effects to be avoided. And what the Supreme Court essentially said was that if the direction is that you avoid adverse effects, then that has to be taken on its face, and you can't say, oh, well, but they might be able to be remedied or mitigated, for instance, by applying an environmental offset somewhere else to achieve an overall better outcome. And so what it means for you, and also when considering other documents, is that if you're going to use words like avoid, then you understand that if an activity can't avoid adverse effects, if they need to rely on remediation or mitigation, then there's a high chance that that activity will be declined. So I've just said at paragraph 35 that we need to be particularly conscious about the terminology used, because it was previously assumed that under part 2 we'd apply a broad overall judgment, and for instance you could take into account positive effects and weigh those against adverse effects, even where the policy framework said that those effects had to be avoided. So that's really no longer the lens that we apply to assessing resource consent applications. And I've just looped back there to the Regional Resource Management Plan having been mostly prepared by King Salmon. It won't have been prepared with that focus, and you'll have to be careful, I think, with applying that in the same way as you would apply the New Zealand Coastal Policy Statement, which has been quite carefully focused. And just at the end of 37, King Salmon emphasises the importance of planning instruments as a reflection of the community's aspirations, and the specific words used will be critical in determining future applications under this plan. So turning to national instruments, I've listed there the ones that are particularly relevant to the panel's decision making. Obviously, these will be picked up by the 42A authors and give you some context where they can. Now, I've just noted there that the requirement is to give effect to those national policy statements. So in some cases that may limit the extent to which relief sought by some submissions can be approved. An example, probably not a great example, but at the extreme, if a submitter had sought relief where they wanted to be able to build within wetland, that wouldn't be relief that you would be able to approve, because that would fail to give effect to the National Policy Statement for Freshwater Management, which places a high degree of protection on wetlands. The national planning standards were also obviously something that came in partway through the preparation of the plan. So ours is one of the early adopters of the National Planning Standard Framework. That also has defined terms in it which are required to be used. So again, I think it's just if a submitter were to seek a different definition of a term, just to be aware that that might be a requirement of the National Planning Standards, and either the relief may not be able to be granted at all, or it may need to be just carefully thought through as a separate definition or an exception or something like that. At 42, I've listed some relevant national environmental standards, and again, one of those will be before you today. We're talking about the National Environmental Standards for Plantation Forestry. Although having said that, that is another one where we were able to reach an agreement as to an appropriate wording for the officer to recommend to you to deal with the interaction between the NES Plantation Forestry and the district plan rules. So obviously the idea of the NES is to set a national guideline for planning rules for a particular activity. And I've just referred to the telecommunication facility one as one that's quite clear and tends to not raise too many issues in terms of the content of the district plan because it's quite all-encompassing. The NES for Plantation Forestry, as you might have picked up from the Section 42A report, and as is conveyed in the advice note that we will be putting forward in response to the Earns Law submission, is a bit less complete in its coverage. So we have just tried to provide some guidance as to when the NES will apply, when the district plan rules would apply. So I've just noted that I haven't included the National Policy Statement on Urban Development in the list above. That's because Central Hawke's Bay is not identified as an urban environment. So that while that document might provide some useful guidance, it's not something that you're required to give effect to it. And similarly, and very luckily for you, I would suggest you're not covered by the Resource Management Enabling Housing Supply and Other Matters Amendment Act, which is causing lots of issues in Auckland at the moment. I've referred there to two draft national policy statements, which at least one of them may come into effect as you go through the hearings process. At this stage, you're not required to give effect to or consider those draft documents. However, as a pragmatic course, I know that the provisions of the proposed district plan have been prepared, being cognizant of what is proposed in the highly productive land NPS, and if and when that does become operative, then we will probably need to address how that fits in with the provisions or the proposed district plan is notified, because the district plan will be required to give effect to that. So to the extent there is potential within what's been notified and the submissions, we would be seeking that we do that in this process rather than having to go through a further change or variation if possible. So again, I'm putting everything on the reporting officers here, but it's their task to keep you briefed on any update on that. In terms of issues of scope, I've set out some of the tests there. In short, because this is a full plan review, it's unlikely that there are going to be any submissions that are not on the plan change, in the sense that often gets raised in the motor machinist, clear view type case law, and that was confirmed by the High Court in Albany North in relation to the Auckland unitary plan, that there's a pretty broad range of topics that can be covered by submissions. So pretty much everything that's within an RMA context is likely to be able to be pursued before you. Obviously, submissions do need to fairly and reasonably raise what they're seeking. And obviously that's for natural justice reasons, that people need to have been alerted to the potential for them to need to provide a further submission to be involved if the relief sought might affect them. So I've noted there that in some cases a submission might be so unclear as to the relief that's being sought that it's not possible to discern the relief. And you, the panel, will need to decide whether, read as a whole, the relief can be reasonably and fairly identified. So the submitter can seek to clarify this at the hearing, but we do need to be careful that they can't expand the scope of their written submission through evidence at the hearing. And again, I've said there that the issue is if the relief sought was unclear, then there may be people who would have wanted to be heard on that topic, which weren't sufficiently alerted to the need to make a further submission. And obviously some submissions will seek relief which is outside the jurisdiction of the RMA, and that's often to do with funding of infrastructure or rates levied by the council, or that are within the jurisdiction of another body such as the Hawke's Bay Regional Council and can't be controlled through the district plan. So once again, for reporting officers, they will be trying to identify any submissions where scope is an issue and raise that with you so that you can make the determination as to whether a submission is able to be, or the relief is able to be considered and granted. And I've noted there that if there's a particularly difficult case, I'm not aware of any, but that doesn't mean they're not there. I'm happy to assist with further legal submissions if that would help. In terms of correction of errors, obviously with quite a large plan, there is some potential for a few errors to have crept in. There's different ways that we can correct those, and I've noted there 16.2 that the local authority can amend that where it's a minor alteration to information, or the alterations of minor, where it's to alter information where that's of minor effect or to correct minor errors. And I've given you the leading case on that, re Christchurch City Council, which went through the tests to consider whether the correction of an error comes within that clause. It is relatively limited in terms of, I guess the main test is whether anyone might have wanted to make a submission on the point had the information been correctly referred to in the notified version of the plan. And the court gives an example there, which I won't run through, but again, it's likely to only become relevant if a particular issue comes before you that you'll need to perhaps go back to the case law and see whether you're satisfied that it's sufficiently minor to correct under this heading. So in some cases, it's going to be so obvious that the council will be able to do it itself behind the scenes. But I've suggested that the more likely path is that the errors will be referred to the panel for you to decide whether you're satisfied that use of clause 16 is appropriate. Now, because corrections can be made under clause 16 at any time, they don't need to await the recommendation or the final decision of the council. I've suggested that you may wish to record your determination in a minute, and that will either be that clause 16 can be used, in which case the council can go ahead and make that change, or if you think that it can't, it's also helpful for the officers to know, because that may prompt them, if it's significant enough, to pursue a variation to the proposed plan to fix up that error. Obviously, the other way that errors can be fixed is if a submission has picked it up, either directly or the submission's broad enough to allow the error to be corrected as a consequential form of relief. And I believe that that may come up in the reports to you today. Officers are keeping a running record of errors noted and how they're to be rectified. So those are my submissions. I'm happy to take questions, or again, happy to provide further submissions when you've got concrete examples in front of you, rather than speaking in theoretical terms, which I know can be a bit tricky.
Thank you very much, Asha. As I said, it was very useful guidance to us all. I know there will be a few questions for you, and I know it's 12:08 now, but what I propose to do, if the panel are happy, is we'll leave the break until 12:30 for lunch. because I think it's important we have some time for questions for you rather than try and juggle the agenda once again. So I might just hand over to Loretta first, just to kick off the questioning.
Kia ora, Asha, can you hear me?
Yes, I can. Thank you. Morning. Well, afternoon.
Afternoon, yeah. I just have a couple of questions. One was just coming back to your paragraphs 46 and 47 with respects to the draft national policy statements. Look, I note your point in terms of, consideration and weight to draft national policy statements, and your subsequent observation in terms of the MPS HPL. But you'll appreciate we've had a number of submissions that are referencing the draft MPS in terms of Indigenous biodiversity. So I thought what I would ask is, where do you sit on the draft MPS IB in the scale of don't give it weight, consider, or give it weight? So that would be helpful in terms of my decision making.
Yeah. Look, I did try and figure out what the status of that draft was. It's the MFE website is much quieter on that in terms of timing, and in fact it's silent on the timing compared to the highly productive land. I think that, yeah, it's hard to say. I mean, the test is that you can't give effect to it because we don't know the final form of it. But certainly if the outcome seems sensible and is relatively aligned with the regional documents and that sort of thing, then that is something that you can consider. I'm not terribly familiar with the content of it or the number of submissions that have been received on it or anything like that, but it may be that the reporting officers are more familiar with that, so could help you on that.
Note that for the report writers, just to be.
Yeah.
Okay, my next question is actually in respect to a question I had in one of the reports, but it's a legal question that I thought I might raise with you. It's probably not one that you can answer off the top of your head, or you might be able to, but you'd be far better than me at doing it. So I might just raise it with you, and if you think
that's helpful, thanks.
Yeah, if you can come back to me with I'll come back to us with an answer later on, that would be great. So my question is around the Man of War case. We were provided a copy. That was from you, or
I think I prepared a brief memo which was attached to Ms. McDonald's report.
And it attached the one, there were a couple, so I'll just make sure I've got the right one. The 2016 one, judgment 2017. So it's the one that covers off the key questions, the 5 questions around ONLs. Basically, as I read it, and I'm reading my screen only because my writing's terrible. As I read it, the court determined that the identification of an ONL is not influenced by the consequences of that classification should it occur. So,
correct, yeah.
Nor is it influenced by activities contemplated or undertaken on or in the ONL, or whether in fact the classification will cause the prohibition of a particular activity after it's classified.
Yep.
And I did, just for observation's sake, note that they reference king salmon in terms of what was inappropriate, and referenced that you had to go back to the natural character and other attributes to be preserved and protected. So that's my starting point. I started to have a bit of a question in my mind when I started to think about, given all of these, and the objective NFL 01 in the proposed plan, how does that align, or is there a nexus with the NFL P5, which recognises an activity, i.e. water storage in the Makaroro Gorge. You can see where I'm coming from. So we've got this case law that's articulating that it is not activity based, and the objective for outstanding natural features is a reflection of the Act and references in appropriateness. I look at the policies and they are largely based on environmental matters. And then I see NFLP 5. A, as submitted, it doesn't actually raise environmental factors, but also I'm not quite sure whether it should be in this section. But for your purposes, I'd be interested to get your perspective about its the relationship of case law to this sort of policy, and whether we can actually have it either in this section or in another. So can you have a think about that for us?
Yes, very insightful question. You're right, I'm not going to answer it off the top of my head. So it's very useful to have that heads up so I can have a look into that for you.
Good, that'd be lovely.
Thanks.
Thank you.
Thank you.
Yeah, hi, Asha. Just in relation to the Makaroro Gorge, just the consents that are in place, is it overwritten? Are they overwritten by the fact that it's an ONL or, is it an ONF or an ONL? Sorry.
ONL, I think it is.
Yeah, it's an ONL.
ONL. Yeah, I think there's...
So are they still in effect, or do they have to go through another process? Because I'm a bit confused as to what happens there.
Yeah. So my understanding is that those consents are currently still valid and would be able to be implemented. They're not affected by the plan setting having changed in the meantime. However, when the new plan provisions would kick in is if there were new consents that had to be sought, for instance, because the original ones lapsed, or because they sought an extension of time to give effect to the consents. At that stage, you do need to consider new objectives and policies that have come into play since the original consents were granted. So at that stage, you would consider whether it was appropriate to extend the life of the consents given the new planning framework.
I think my question was just in terms of general water storage and things like that.
Okay, Tim. Okay, thank you. Oh, you do?
I had time to think about one. I'm not sure if this is Kate here. I'm not sure whether it's appropriate at this point in time, but I would like to know if in Appendix 1A5 in your report says, have regard to any relevant management plans and strategies under other acts. And I'm wondering if the submission from FENS talking about standards and also the legislation that covers Ngā Whenua Rahui and QE2 covenants would be applied under that example.
Yeah, I certainly think that QE2, the legislation around the QE2 covenants would be a relevant consideration under that head. In terms of the standards, I think they could be, but it would depend on the context. I'd probably need to go back and see exactly how those standards are referenced. I mean, in one sense, if an activity is covered by standards and it doesn't need a district plan rule to implement those standards, then the appropriate course is for the district plan not to interfere, not to double regulate things. So it may be relevant in the sense that it rules out the need for a district plan rule to cover that particular matter. But I have to admit, I can't recall the reliance that FENZ is placing on the particular standards, whether they're actually wanting them included in the plan or just referencing it.
Referencing that back to the, there's also like the plan references the Hazardous Substances Act.
Right.
I've got that right, for example. But that's actually an act where these are standards. So I wasn't unsure of the legal standing of the difference between the two.
Yeah, that might be something that I could just check how that's referenced and whether that would be appropriate to take into account under that particular aspect of the statutory test, or whether it comes in somewhere else. If that's okay for me to come back to you on that.
Thank you. Just a couple of points, really. The first is to make a point rather than a question. Your comments around Hort New Zealand, in this case, agreeing to the officer's recommendations and then therefore not attending the hearing to talk to that. I think I would like to just highlight that is a risk that the submitter will be making, that we may not agree with the officer. And so they've forgone that opportunity to talk through why they support the officer's recommendations and what have you. I mean, that is their choice and I accept that, but I just want to be clear to all parties that we're not necessarily going to be in line with the officer's recommendations all the time. So to make that point. In terms of the age of things, you helpfully pointed out the age of the Hawke's Bay RPS and regional plan. You said it will not always be appropriate for the panel to apply the policy statement without considering part 2. You did refer to incomplete coverage might be one of the critical things, that there may be an aspect of it that's not covering what we need to be addressing. Is there any other sort of guidance you can provide around what to look for at the RPS that may flag that it's inappropriate to apply?
In a general sense, I don't have any particular examples. I mean, I guess where it might bite, for instance, if the strictly speaking, you're only required to look at the regional policy statement because that's the next document up in your list. But for instance, if the regional plan didn't fully address the New Zealand Coastal Policy Statement, which I suspect is the case, then that would be appropriate to go up to that next level. So things to be aware of, and I guess particular examples might be picked up by the reporting officer. I might have to come back to you with any pointers on that, because it's sort of quite a big document. So I'm trying to think of something that could assist you on that. I suppose if there's been a more recent national policy statement, for instance, that in theory should be implemented by the regional plan, but obviously hasn't because it's come out since the regional plan was confirmed, and an example of that might be the freshwater management NPS, then it's obviously going to be appropriate for you to go direct to the NPS. But then in that case, not up to further to part 2. So that's one example, although possibly not the most helpful.
Yeah. And in terms of age, it's just a final question maybe. In terms of age, it's not age of a document that's important in terms of king salmon. It's those 3 absences.
That's right.
So for instance, the NZCPS is now well overdue for review. But that's not relevant for us. What's relevant is if any of those absences apply to our situation here.
That's right. Yeah, and that's what, for instance, I think the NZCPS has got very good coverage, so it wouldn't come under the incomplete coverage, whereas I think some policy statements do leave out or are particularly focused on one aspect, but are quite clear that they don't cover other aspects which will also be relevant to the Commissioner's decisions.
I don't have any more questions. Any other questions from the panel? No, thank you very much, Esha. That was very enlightening.
Thank
Very
you, and
helpful.
I'll come back to the panel as part of the Council's reply with hopefully some more useful answers to those very good questions.
Yeah.
Thank you. Good luck.
Thank you. With that, we'll adjourn for lunch break and we'll return at 1 o'clock and resume the hearing.
What you want? Goodness.
Good.
Gonna put our camera back on for you guys.
Yeah. Off on YouTube.
Yeah, thank you. So it's just gonna be on Rowena and Stella.
Okay. Well, good afternoon, everybody. Did a good lunch. The hearing is now convened or reconvened. And this part of the agenda has the Section 42A report authors summarising and talking to the main points and being available for questions. So who would like to talk first? Whose summary statement are we first? So I'll just bring it up. So which topic were you covering?
I'm covering the ecosystems and Indigenous biodiversity topic and the open space and recreation public access and facilities on the surface of Flora.
Would you like to start? Thank you.
My name is Stella Morgan, and as I've just said, I've prepared 2 Section 42A reports today. Biodiversity and the second one on the open space and recreation, public access and activities on the surface of water provision.
Can you just stop? You did provide a little summary
Yep.
document that you're talking to. Has everyone got that in front of them? It was emailed this morning.
Oh, I emailed this morning.
Was it emailed this morning?
May just have the box on and
Okay.
thanks.
So the purpose of my opening statement is just to provide you with a little bit of context and highlight probably the key issues that I've addressed in the report. So I'll talk firstly with respect to the ecosystems and Indigenous biodiversity Section 42A topic report. And that covers the provisions in that chapter of the plan as well as related definitions contained within the interpretation chapter. A number of submissions were also received on specific sites listed in the schedule, Schedule Eco Shed 5, Schedule of Significant Natural Areas, which relates to this chapter. But due to the need for a number of these sites to be ground truthed by Council's consultant ecologist, these submission points have been held over to a later hearing. And at this stage, we're looking at hearing stream 6, to be held later in the year. So this, the submissions that I'm addressing today focus on the actual provisions rather than the mapping. There were also 3 submissions from Nahapu Ngā Marae o Tamatea that have been moved for your consideration to hearing stream 4, which will be covering tangata whenua and historic heritage provisions of the PDP, of the district proposed plan, sorry, and that's to enable these submission points to be considered alongside like submissions on those matters. So we haven't overlooked them, we've just transferred them to another hearing. So turning back to the ecosystems and Indigenous biodiversity chapter, the reason for these provisions is because Council are required to recognise and provide for matters of national importance, including the protection of areas of significant Indigenous vegetation and significant habitats of Indigenous fauna. So that's a Section 6C matter, and it's a requirement council to provide for them. There's also other matters, section 7D, that's relevant, that requires that in achieving the purpose of this Act, all persons exercising functions and powers under it in relation to managing the use, development and protection of natural and physical resources shall have particular regard to the intrinsic value of the ecosystems. In addition, section 31B3 provides that every territorial authority shall have the following functions for the purpose of giving effect to this Act in its district: the control of any actual or potential effects of use, development or protection of land, including for the purpose of the maintenance of Indigenous. So there's some clear direction or expectation from the Act that these matters will be addressed in a district plan. Just by way of overview, and as set out in my section 42A report, I think it's really relevant to note that these provisions update the operative district plan schedule, which is Appendix D, and mapping of areas of significant nature conservation value, and replace the nature conservation provisions contained within the rural zone provisions of the operative district plan. Those sites that are scheduled in the operative plan in Appendix D and identified on the planning maps, they're based on Department of Conservation information, recommended areas for protection, or RAPs as they're commonly known, from 1994, and other doc information available at the time. They're quite a broad, well, they're a very broad brush identification. And so that mapping's been there the whole time we've had this district plan. The operative district plan rules provide that there shall be no modification to sites of significant conservation value, and those are the sites that are mapped as ASC NCVs and listed in Appendix D, or no modification to sites with naturally occurring tree species of 30 centimetres in diameter or more over 1 hectare, if the canopy is over 6 metres or 5 hectares of any height. There's some very minor works that are permitted in areas under 5 hectares, and it's basically limited to maintenance or repair of existing roads, tracks, fences or drains, and activity associated with plantation forestry. And my reason for just pointing that out to you is that both the mapping and the scheduling of sites and rules are not new to the district, and the actual operative plan provisions are quite restrictive. Nevertheless, I do understand that there have been few, if any, resource consents received by council in relation to these matters. So the approach that's been adopted in the proposed district plan is underpinned by our consultant ecologist Jerry Kessel's review of the district's natural heritage. They provided the basis for better understanding the district's natural heritage resource that met the tests of section 6C, and also to provide guidance on methods for meeting council's section 6C responsibilities and other responsibilities. His methodology is based on a set of assessment criteria, which is set out in the policy, Eco Policy 1 and Appendix Eco 1. And he applied that criteria to the district and produced a GIS-based data set and schedule of sites for inclusion in the PDP. So this was predominantly a desk-based assessment, refined over time as his methodology was developed across his 3 reports that were produced. The first review report provided an analysis and interpretation of aerial photography, information from ecological reports and data, and applied local ecological knowledge to develop a provisional inventory of significant sites. These sites were then reviewed as a result of consultation with the council, landowners and other stakeholders, and included a series of landowner meetings, community workshops, and then a draft plan process. We requested, and at the invitation of council, ground truthing of a number of sites was completed and those sites were reviewed. In the second review completed by Jerry Kessels, there was an analysis of additional vegetation, wetland and migrating river data sets. And he produced a revised polygon data set that comprised a number of minor edits to increase the accuracy, basically increase the accuracy of the mapping to better align with vegetation boundaries. That review also took into account the approach advocated by the draft National Policy Statement for Indigenous Biodiversity when it was released in 2019. The third and final review sought to finalise the scheduling and mapping of significant natural areas, which is what we're now calling these areas for inclusion in the PDP. And throughout these reviews, there's been a note of the limitations of the SNA identification, including that it is a desktop review with limited ground truthing. The ecosystems and Indigenous biodiversity provisions have sought to align with the provisions of the draft NPSIB. And just following up on some of the conversation this morning when Asha was online, that I think the way we've approached it for the plan is it is a draft, so we're not bound by it. However, we've considered it as being probably the current best practice on Indigenous biodiversity. Of note, the draft was developed by a stakeholder-led biodiversity collaborative group that comprised representatives from Forest and Bird, Federated Farmers, New Zealand Forest Owners Association, Environmental Defence Society, a representative of the iwi Chair Forum through Taio iwi Advisors Group, and as well as representatives from infrastructure industries. So where possible, we have sought to align the draft provisions with that, the proposed provisions, with that draft. Despite being released in 2019, it has remained in draft form, and there's still no clear date as to when that's going to move to a proposed piece of legislation. So it doesn't have any legislative weight. And as I've mentioned, it's considered to represent the current best practice. How I sort of think of the rule framework that we're proposing in the plan is that it's like a cascade or a sieve approach. So it requires any applicants who may have Indigenous forestry or Indigenous vegetation on their property to work their way through the provisions. It's not a simple yes, you're this, no, you're that, no, or no, you're not. So just by way of summary, the first rule does identify a number of types of Indigenous vegetation that the plan doesn't seek to regulate. So areas of domestic or ornamental landscaping, planted shelter belts, plantation forestry undergrowth, or plantation Indigenous forestry. Those consent is not required for any trimming of those. However, consent is required for trimming and clearance of Indigenous vegetation that comprises naturally regrown manuka or kanuka over certain thresholds, and they comprise a mixture of area, tree diameter and height. That's proposed Eco Rule 2. Consent's required for any vegetation excluding natural wetlands that meets one or more of the ecological significance determination criteria, and that's set out in Eco Rule 3. If it's not the manuka in Eco Rule 2 and is over certain thresholds, then Eco Rule 4 applies. If it's outside an area of significant Indigenous vegetation or significant habitat of Indigenous fauna where sites exceed certain thresholds, then Eco Rule 4 applies. So that's basically, that rule is basically acknowledging that the mapping is desktop and may not have always caught all the vegetation. So it then requires you to go and have a look at that to determine whether it's significant or not, and whether you, and then what sort of consent you might, what sort of conditions you might, mitigation you might need to look at. There's what we're calling a wash-up rule in Eco Rule 5 for anything else that hasn't already been provided for. And then anything that comprises part of a natural wetland that is identified as an SNA requires a consent. So that's the rule framework. In terms of the submissions and main matters in contention, there were 27 submitters who made a total of 161 original submission points on this topic. There were 130 further submission points in support of or opposition to those. Of the original 161 submission points, 76 were in support, with the remainder seeking amendments or opposing various aspects of the relevant provisions. They covered the submissions opposing covered a wide range of aspects and a broad range of matters, from minor corrections through to requests to delete various aspects of the chapter. As a very broad summary, matters in contention include amendments sought to definitions to clarify or change the meaning, amendments to better recognise kaitiakitanga and the relationship of Māori with Indigenous vegetation and fauna, the development of Māori land that may have that has an SNA overlay on it, general opposition to identifying SNA and imposing restrictions or greater responsibilities on landowners as a result, including opposition to SNAs on land that were protected by QE2 covenants or some other similar instruments. A lack of assessment, and that was particularly referring to the Section 32 report to justify the provisions or lack of relating to plantation forestry activities, and a lack of clarity as to when the proposed district plan rules apply to plantation forestry. Some minor amendments to biodiversity offsetting provisions. Various amendments were sought to clarify the ecological significance determination criteria. And then a number of amendments to other policies, which I've listed there, as well as a new policy relating to sites that are already protected under other legal mechanisms. Various amendments were sought to the eco rules and a number of other minor changes. I don't tend to cover these matters in my opening statement, as they've all been addressed in my Section 42A report, along with my recommendations in response, some of which were considered by Mr. Kessels and are covered in his statement, which is also attached to my Section 42A report. Having read the evidence and legal submissions, I filed supplementary evidence in response to 3 matters. The first was submission point 81.073 from Horticulture New Zealand with regard to biosecurity provisions. The second was in response to submissions from Rainier Mahari Forests and Earnshaw One Limited in relation to with regard to clarification of the relationship between the NESPF and the proposed rules. We have some subsequent agreed revised wording for an advice note to precede these rules, and a submission from Federated Farmers who identified a mistake in their original submission and asked that we reconsider that particular submission point. So that was made available on Friday. Was it Friday? I don't know if you want me to summarise that or take it as read.
So it's the PDF dated 11 March, is that the one?
It was Friday.
Right on the top. I'm not sure the commissioners have had a chance to read the whole thing.
I can quickly go. Do you want me to?
Just very briefly, if you could, but we will take time to read it between now and the end of this hearing.
Okay, so the matter in terms of Hort New Zealand's submission point, they had their original submission had wanted a specific rule in relation that allowed for biodiversity activities. We, in the first instance, I recommended that was rejected because I didn't really understand how the RMA and the Biosecurity Act worked, because the Biosecurity Act allows you to override the RMA in emergencies. What they came back with and said, well, there are actually other situations where it's not an emergency, but can still have a biosecurity response is still required. And as an example, they talked about the kiwi fruit industry, which was, I can't remember what the disease was. Yeah. And they said that wasn't an emergency, but it meant that that in some areas they had to go in and get a consent to be able to address that. And what they were asking for was to have an exemption for that. So having considered that information, I thought that was a reasonable exemption. And in Eco Rule 3, there are a number of exemptions. One of those does provide for activities undertaken under the Biosecurity Act. What the Hort New Zealand evidence highlighted for me, they asked for that to also apply to Eco Rule 4, which is, Eco Rule 3 is for activities within an FNA. Eco Rule 4 is for activities outside of an FNA. So we didn't have any exemptions for Eco Rule 4, essentially. So having thought about it, what I came back with was a new rule, Eco Rule 1A, which basically lifts all those exemptions that apply to SNA into a new rule category of its own, and then they became exemptions whether you were within an SNA or outside of an SNA, and then took those exemptions out of Eco Rule 3. That's a very complicated way to explain it. So it looks like a big change, but it's essentially just a reshuffling of where it is as a result of a gap highlighted in relation to Eco Rule 4. That's the intention. And so whilst they only asked about biosecurity matters, and I discussed this with Asha, and we felt it was reasonable to apply it to all those exemptions. Otherwise, they would have had an exemption all on their own, and that didn't seem to be quite fair. So that's how that's, and so Hort New Zealand have come back and they're quite happy with that response. So on that basis, they elected to not. Yeah. So that's the Hort New Zealand one. And then the next one was from the forestry companies. And in their evidence, the note preceding the rule and the PDP, they submitted alternative wording. And then again, on Ash's advice, we had a meeting with them to further refine that wording. And the wording that's set out in my supplementary evidence is essentially a clarification to that note. And while generally we probably try to avoid paraphrasing what another piece of legislation says, the NESPF is a really, well, for me anyway, it's quite a challenging piece of legislation to get your head round and to understand how it fits together with the RMA or with the district plan. So this was an effort thinking of the people who are going to have to administer the plan further down the line, that they can get really clear on when the NESPF doesn't apply and the district plan rules apply. So a memorandum's been filed to basically say that all those parties have agreed on it. So council officers and the submitter from Rainier and Ernst Law 1. The third matter was from Federated Farmers. They provided a correction to their submission point in relation to Eco Policy 2 and asked if I would reconsider it. And I have reconsidered it, and I still stand by my original recommendation for the same reasons that I outlined in my section 42A report, and I have recommended, I don't wish to change my position on that submission point. So that's the supplementary evidence. Other than these matters, I don't have anything further to add at this point, but I do anticipate returning to these matters in my formal reply following the hearing. So my second report is in relation to the open space and recreation, public access and activities on the surface of water provisions of the plan. And in general, these chapters represent a rollover of the operative district plan provisions, with any changes generally reflecting the requirements of national planning standards. And just by way of a little bit further clarification, when I say a rollover of the operative district plan, one of the fundamental assumptions right back at the beginning of when we were reviewing the district plan was to take an approach that if it ain't broke, don't fix it. So if an issue hadn't been identified or the legislation hadn't fundamentally changed, or there were no reasons to be revisiting it, we pretty much would accept the status quo. That worked in practice somewhat, not always particularly well. So these chapters are an example of that. The open space and recreation chapters, you'll see there were only 2 submission points on that, and they were both in support. Just to note that in this district plan, open space is not zoned, which is probably different to a lot of district plans, and the open spaces generally rely on their designation. They're designated in the plan. Community and recreation facilities are identified in the plan, but that's for information purposes only. And recreational activities themselves fall within the definition of community facilities, and that's a kind of a, what you call it, not a legacy, but that's a national planning standard definition, which I've always found a little bit tricky because I don't necessarily think of facilities as activities, but there you go, that's where recreational activities are placed. And they're generally permitted across the zones. So accordingly, this chapter doesn't have any rules. The public access provisions, they respond to a matter of national importance, 6D, that requires council to recognise and provide for the maintenance and enhancement of public access to and along the coastal marine area, lakes and rivers. The planning maps identify the district's important water bodies, and in this chapter and associated subdivision provisions seek to prioritise the creation of esplanade areas to provide public access to and along these areas. There are 15 submission points and 12 further submission points received on this chapter, and 10 of the submission points supported the provisions, 5 sought amendments. Key matters in opposition are, in summary, the need to address access by mana whenua to wahitapu on private land or to cross private land to sites of particular significance. Clarification of matters related to esplanade reserves, and in particular policies PA1 and PAP2, and a request for a new policy regarding compensation for esplanade reserves. And a request to include reference to private land in policy PAP4, and a request for a new policy to advocate and educate about public access. My report notes a mapping error that has resulted in sections of the priority water bodies being left off the planning maps, and in particular this includes Lake Pātuma and key rivers east of the main townships of Waipawa and Waipokoro. And this will need to be addressed through a wash-up variation to the plan. The error does not affect the content of my report, which relates to the provisions that will apply to these priority water bodies. And I note there were no submissions received on this matter. And Asher also addressed the matter of correction of errors this morning. And then activities on the surface of water. This addresses Council's RMA responsibilities under Section 31E to manage the control of any actual or potential effects of activities in relation to the surface of water in lakes and rivers. There were 13 submission points and no further submission points on these provisions. 11 submission points are in support, 1 seeking an amendment and 1 is in opposition. And that's from Jet Boating New Zealand, who I think are appearing later today. I've read the submissions and statements and submissions, and I do not have anything to add at this point, but anticipate returning to these matters in my formal reply following the hearing. In conclusion, I anticipate that the panel may have additional questions over the next couple of days or now. And I note that Mr. Kessels will be available to the panel for questions at the end of the hearing of submissions. And I will provide the panel with a formal written reply on matters raised during this hearing where we're requested to do so, or where there are matters where a response would be helpful to the panel. And I understand that we are to provide our written replies no later than 10 working days following the adjournment of the
Would you like to take questions now or panel? Okay. Any questions? Okay. Questions? Okay.
Of course I do. Just to clarify, when you say, I'm sorry, I was jumping between things, that tangata whenua matters will be dealt in the hearing. You do, in your report, refer to some tangata whenua
Yes, it
matters.
was just those particular submissions.
So,
So do you want me to tell you which ones?
no, it's fine. It's just, I had some, I did note that, and I think in was the economic ecosystems one, you did say that there were some that would be deferred,
Yes.
and then you discussed others. So I'm just making the distinction. Are they all deferred now? So we don't have to look at that, or can I comment on some of the ones that you did actually make recommendations on?
So it's just there's 3 particular submissions that I've deferred, but it's not all submissions from tangata whenua submitters. So the 3 particular submissions were in relation to I think new objectives and policy relating to Te Mana Otiwai matters, and there's also been submissions on the strategic tangata whenua chapter of the plan that also talks about those matters. So it was really allowing those to all be heard together. So it was just those 3, but yes, you're correct. There are a large number of other submissions from tangata whenua submitters that are being considered in today.
What's this question now on that?
I was going to ask, any questions from the panel for you in relation to the whole 42A report? They're not confined to what you just heard. So if you want to ask any questions on the 42A reports, this is the opportunity. Another opportunity. Here's one.
Yeah, because I have to admit, all my questions are actually on the report, since I only just got this submission.
So yeah, I'll just sort of make that clear to the panel. There's the whole report is now open to questions if you want to. Sorry.
I'm just saying, did you want to talk about like BSNA stuff and co-governance?
Yeah, there is the question around things like co-governance and those sorts of things. Are you deferring those sorts of matters until?
Because they are discussed in your,
Yeah.
some of your parts.
So where I've discussed them in here and made a recommendation, that stands in this. But yes, it may also come up again. But there's probably a number of themes that are repeated across some of those tangata whenua submissions. It was just those particular ones, Te Mana Otiwai, I wanted to make sure that they were heard together.
Yeah, I'm just mindful that it's likely that those matters will have to stay alive post adjournment,
Absolutely.
simply because they'll be presenting on them at that time.
Yes.
So I just wanted to clarify that it wasn't closed off. So if we go through your ecosystems and Indigenous biodiversity paper, I'm sorry, I did literally start writing. So in terms of the SNAs and identifying the SNAs and understanding the various reviews, do you have a sense of the list of SNAs originally, how many of them were ground truth or asked to be ground truth? And have any of those that were ground truth, are they any of those still extant, or have we dealt with them? Or is this a Kessel's question? Feel free to tell me it's a Kessel's question.
I can probably give you a little bit of an answer. I might have to ask Helen to assist me.
Give it to me later, that'll be fine.
Yeah,
I just want to understand where we've gotten to in terms of reducing down to the few. And equally, I guess, and this might be a Kessel's question, given Mr. Kessel's went and did all the consultations. I was wondering if there was any uncertainty about whether we've picked them all up or whether we've picked some up and people in the district just aren't aware that they're actually covered by them and so therefore haven't submitted or ground truth. So I'm just trying to unpack where we are literally in terms of SNAs, because there, as you'll appreciate, there are submissions on both sides about, is this it or is this not? So I just wanted to unpick that a bit. So if you could just come back to us on that, if that's okay. Another point on that, and this was at your paragraph, I think 5.343, just so we covered it all. And it's about challenging once the plan's done. So as I read it, on that one, once the plan's complete, the SNA is in, owners then have the opportunity to challenge through a resource consent process, or I guess a plan change. We've had submitters actually articulate or recommend the reverse, place the burden on the council. So take anything that's not absolute out, let the council do the work to ground truth, and then let the council bring them back in. Given we have submitters that are saying that, you know, there is a considerable expensive burden to place on them, what are your thoughts on that? Because of course that's something that we have to consider in terms of the balance.
So I guess the approach to taken to the mapping or the identification of SNAs is to a large degree a pragmatic approach. The ground truth is a very expensive process across the district. So the approach was taken, that was why the approach was taken that it is, and then the resource consent process was seen as a way of then addressing, clarifying that or addressing that. And yes, I guess there is an acknowledgement that that is a cost to the landowner. And I think there has been talk about whether there's some method of being able to assist with that. But again, that's outside of the district plan to address that. It was a balancing exercise at the end of the day as to this massive cost to go out and ground truth. I can tell you what the hectares are if I can't tell you off the top of my head, but it's some considerable amount of land, to having an approach that's a little bit more pragmatic, that says we've used all the information that we've got available and we've mapped it on that basis. I mean, because there'll also be matters of boundary where the line on the map falls, you know, that even with ground truthing, by the time you map it, you can get some sort of error. So again, the resource consent process was seen as the appropriate place to kind of tease that out. But yes, it does place a cost on the landowner. I guess I would say to you, and it might be a better question directed to the ecologist, but my understanding is that a lot of the SNA areas are within the, what do you call it, the river, the incised river areas as well. So yeah, in my mind, that's often land that might not otherwise be used. But yeah, again, those are very general broad assumptions.
Okay, yeah, it might be helpful if Kessel's provides us some feedback in terms of his experience. I did note from his evidence that he did talk about his experience of working through and having the conversations with people. So it actually would be quite helpful to give us, you know, help us with the confidence that this process has been robust enough if we're going to take the view of putting the burden on landowners. I can stop and start again if you want to let somebody else do some talking. This is one of those ones about Māori matters. So picking up your paragraph 6.3.8, and 11. I guess, and in fact, I think I worked my way through to we started to get to the recommendations and things. I'm just mindful that, and I know we will be probably dealing with it in other matters in terms of freshwater habitats and things like that, but the MPSFM does contemplate local councils providing access, etc., for providing involvement in the relationship for Māori in terms of mahinga kai and mātauranga and things like that. So when we start looking at things where the Heretanga Tamatea Trust talk about incorporating, you know, a objective in terms of acknowledging that relationship within the SNA, which will likely have flora and fauna of significance, and also, you know, their desire to have their mātauranga Māori as a criteria. Perhaps what I'm saying to you is it is contemplated in the MPSFM, admittedly more at the regional council level, but there are sections in the MPSFM that do contemplate local councils taking a role in terms of how they engage with Māori. So I would perhaps counsel you in terms of this report and reflecting on SNAs that and relationships with tangata whenua, that is an opportunity actually to incorporate them and reflect the NOF in the plan. So that's something I would just wanted to observe, because I sort of went through and felt that there was an opportunity missed. I also note again that distinction of needing to allow Māori to actually speak to a few things, that 6.3 of 14 is where we start to discuss co-development and involvement, and we've made some recommendations on that, but I think we're going to have to acknowledge that Māori, the iwi tangata whenua, will have a view on that will need to be considered as part of that. Just on the issue of Māori land, do we know how much Māori land is actually in the SNAs? And just on 6.3.19, again, in terms of the Māori matters, and this was something that I was I've got my questions around face.
Sorry, what paragraph was that?
6.3.19. So it's this conversation about Māori land and utilisation. Now, and I noted this in one of the previous reports that we need to discuss, but there is an emphasis on the PKH, Papakainga and Kaumātua Housing and Associated Marae-based development chapter as a reference for development on Māori land. I think I would counsel you on that, for waiting for the tangata whenua to have perspective. But I did note that, I think it was Ngā Tere, who talked about development on Māori land, which, from my perspective and knowledge, referring to them, is not always limited to Papakainga and housing, particularly when you're dealing with iwi settlements. So acknowledging that we're talking about SNAs, acknowledging the point that any process for utilisation of land, including Māori land, has to go through a process of reflecting of SNAs. But I would hate for a report or an assumption that it's only limited to Papakainga and rural housing and marae in terms of what Māori would perceive as development, because again, we have to wait to see what the tangata whenua say. But in terms of at least one submission, I got the sense that it was wider than that. I might leave the QE2 to you because we've got a question around that.
Yes.
I'll stop there. Just on that. I think in terms of my open spaces comment, again, I identified the fact that the open spaces one was probably even more silent on Māori matters, and recommendations in terms of that were another one. So paragraph 5.51 and 5.52, I thought were really obviously silent on opportunities to have the Māori voice in there, and they've asked for it. So, even as something as simpler, when you look at PAM3, given Māori have asked for access to mahinga kai, which are inevitably, if we're talking about they'll be in that SNA in that area. When you're talking about negotiating with landowners, there's every chance that you'll be enabling access to mahinga kai. So why not add, and when you say you're going to inform the public as to the locations that you'll inform iwi and Māori of locations where they might be able to access mahinga kai. So it's ensuring in the plan that Māori can actually see themselves. And sometimes it's as simple as just looking at it from their point of view and how you can help that.
I'm just aware of the time, so we've got about just 5 minutes. But there's a number of points in your report where you suggest that certain submitters might like to comment on points or clarify what they meant or things like that. I haven't got a handle on whether that's been achieved or not, or you're satisfied that they have responded to that point or question?
I think the ones we've addressed through the supplementary evidence were the ones we felt we could progress and get sorted before the hearing. The others, I would be coming back to you and probably in my right of reply, and after having heard. I think I've got on here, so my green ones are the ones that agreed and my blue ones are the ones that don't. I can respond to those in my.
Thank you. Just getting back to that big picture question, that Loretta was asking around the size. So what is the, remind me, what is the smallest scale SNA that's been mapped?
I think we had a half.
Half a hectare.
Half a hectare.
Okay. So in terms of the legal advice we got this morning from Asher, we have to weigh up the risks, the cost, the efficiency, and all those questions. And you yourself said that there was not many, if any, consents granted under the operative plan around this thing. So the question for us to contemplate, one of many, is what are the risks? So if we exclude the under half a hectare things from subject to the rules, what are the risks of doing so versus the benefits and the costs? That's one thing. We probably wouldn't mind some advice from Dr. Kessels around that. I don't have a big sense of what are the nature of these smaller pockets of potential SNAs to the district or to New Zealand widely. And then related to that is the QE covenant. So I think that was rejected as being an exclusion factor because not all QE2 covenants are protecting SNA values. And again, I don't have any sense about how real that is in terms of a real big issue. Is it like most QE2 covenants wouldn't cover SNA issues, or maybe just the odd one or two? I don't have any real sense of that myself. I wouldn't mind some advice on that. I might, given the time, because we do have another seminar shortly, turn to the.
May I just, with regards to the same issue, I think it's 2.3.15, but it's possibly 12.3. I've screenshotted it and they've missed the one. You've mentioned that it was important that natural heritage resources recognised regardless of a site's legal status. And in regards to the question I asked Asher earlier about what standing do we give other legislative acts or bodies of work, going back to her comments about having regard to any relevant management plans or strategies under other acts and the extent to which it is the most appropriate way to achieve the purpose of the act. My question is, how can we look at this from a different direction to meet the same objective under the RMA in an exclusion or a exemption or something else?
I guess my comment would be that, and I have spent some time in my report, but I just don't quite know where it is, given it's a big report, about what the RMA requires under Section 6C versus the protection under QE2, for example. And Jerry Kessels will be able to speak to this more, but at a very broad level, that my understanding of the resource is the resource. His role was to identify it in terms of Section 6C matters. So he did that regardless of any legal instruments that applied to the land. Then our job as the planners was to provide a set of rules that then looked at the best way to protect or to meet the requirements of Section 6C. So with respect to QE2 and other covenants, we've said actually, yeah, those do achieve a really good level of protection. So they're excluded in that rule 3. I think if it's got one of those applying to it, then that rule doesn't apply. That's the intention.
I think we might just stop there because we are due for to hear from Fins, and but we are proposing to have you available after the last submitted today, 4 o'clock or the year after, to carry on this conversation. Okay, thank you.
Okay, so we have Bob Palmer, Nigel Hall and Paul McGimpsey on fire and emergency.
Bob, who's going to lead the charge?
Hi, everybody. I can sort of introduce us if you'd like. Nigel, Bob, I see you're online there, which is great. Would you like me just to start?
Just a moment, please. We do have another submitter on at 2:15, so yeah, if you could start, that'd be great. Thank you.
Yeah, sure. I think I can be reasonably quick. Yeah, my name is Paul McGimpsey, and I'm a planner at Becker here on behalf of Fire and Emergency. And with me, I've got Bob Palmer and Nigel Hall, who are both based locally in Hawke's Bay. I submitted evidence, which I'm sure has been read. I guess probably just in summary, there's a good level of agreement, I think, in terms of the reporting officer's recommendations around the matters that Fire and Emergency sought in its submission that are being covered in this hearing stream. And I guess my evidence and indeed what we thought to focus on today was probably a couple of areas. One where the recommendation from the reporting officer was to reject the relief sought by Fire and Emergency, and the second was an invitation by the reporting officer to provide some additional information in relation to one of the submission points. I'll just take guidance. Do you want me to cover that first matter where the reporting officer was recommending rejecting Fire and Emergency's submission points?
I'm just going to stop and just talk to the reporting officers about whether there's a scope for some outside expert conferencing to occur. Yes. Just to resolve some of these matters, because they seem to, my mind, matters that could be resolved readily with a bit of discussion. Yes, please. Do you mind, Paul? I just want to hear from Rowena.
No, of course. Yep, of course.
Just very briefly, I think where I am getting to on this one is more, it's going to come up in 2 or 3 hearing streams across the various zones. So it's probably most relevant to the rural environment because it's regarding sites that are, well, generally from what I'm taking from your submissions, it's more about sites that are in the rural area where they're not connected to articulated services. So my sort of feeling about that is that maybe it's about making sure that we have that covered somewhere, whether it's through rules in the plan or some other provisions, and I'm definitely open to talking to Fire and Emergency about that and seeing if we can come up with something that would be workable. Yeah, the options so far still not 100% would work, but I think we can possibly find some way through. So I'm quite open to discussing that with.
So does that cover all of his points that he's made today, or
that's right? That's mainly in relation to the servicing matter, which I think is the only ones that are sort of sitting outstanding. I think the rest we've covered off, or they have, or Fire and Emergency have resolved away from, which is the hose drying.
Yeah, that aligns with my understanding as well. Yep. I suppose that there was that point around the vegetation clearance and the invitation of, to provide a bit more context and information around that, which we're happy to do here. But yes, very happy to work outside of this process and kind of try and come up with something that is workable. Yeah.
Okay, I don't want to take the wind out of your sails, but if you think that's a good approach, because to me it's far preferable to do it that way than it is to feed it out through the hearing process. But it would be on a without prejudice basis, so that if you don't agree, you are more than entitled to come back and tell us why you can't agree. That's the only risk I see about doing that. And that could be covered in the right of reply. I'm just trying to think here.
If it's okay through you, Chair, I'm thinking that it might take a little bit of time, and we're in the throes of writing more reports at the moment. So I'd like to park it for the rural hearing, and come back to the rural hearing on that.
Would that be acceptable to FEMS?
Yes, I think it would. You're absolutely right in terms of the nature of our concerns and interests. They do repeat through a lot of the various topics and zones, and yeah, particularly pertinent to the rural zone. So yes, yeah, absolutely, that would be fine.
Are there any? You've got the floor at the moment. Are there any matters you think would be useful for the panel to hear in your statements, other than necessary matters of detail?
Well, look, given that we do have two fire emergency people on the call, and there was an invitation from the reporting officer just to provide a bit more explanation and context as to the importance of being able to clear vegetation in certain circumstances where they pose a fire safety risk. I might ask if Bob and or Nigel could speak for a couple of moments to that. But before they do that, just the context of this is one of our submission points, or fire and emergency submission points, was just seeking an additional assessment matter, so that where a resource consent was needed to clear Indigenous vegetation, and I think there was another rule around Manuka and Kanuka, that if part of the reason for an applicant seeking to clear that vegetation was for fire safety and fire mitigation measures, that matter could be taken into account in deciding on a resource consent application. Certainly wasn't seeking to change the need to obtain a consent or the triggers or anything like that. Yeah, would a couple of moments from Bob and Nigel be useful there?
I think so. I believe so.
Yeah.
Yep.
Okay, over to you, Bob and Nigel. You're both on mute still, by the way, on my screen.
You just have to unmute. I'm asking you to unmute.
You got me.
You're both unmuted.
Good afternoon. Just a way of introduction. I'm Nigel Hall. I'm responsible for community risk throughout Hawke's Bay. So that's all risk, whether it be the built environment or the natural environment. And I've been with New Zealand Fire Service now for 12 years, previously 30 years in the London Fire Brigade. So that's my background. I'm very passionate about reducing risk, and especially as climatic changes have increased the risk in our natural environment. And I think we've all seen that occurring, not only internationally, but also in Hawke's Bay, and particularly in Central Hawke's Bay. And I know that you'll be fully aware of what the dryness can cause during a hot summer. Fortunately, this year we had a fair bit of rain, and we didn't have the number of calls we had in previous years, especially down that State Highway 50. And there is a strip that continually gets dry down the coast as well, so quite pertinent to this hearing. So, I think I'd just like to say that we all see the big fires on the news, and we've probably been witnessed them in our own environments, but they all start small, and without adequate water supply in those initial stages, they get bigger. So the importance for me for this hearing is that we do account for adequate water supplies in all new builds and new subdivisions for firefighting purposes. And we need access to those as well, which is really important. And yes, there are certain tree types we don't like because they burn very easily, and others we prefer to see. So we can provide details of those ones that don't burn so well and ones that do. But having seen what happens to to a cypress tree when it's alight. It gets to a certain temperature and it literally explodes. So you don't want that within 30 meters of your home. So that's my views on the matter, having been there, fought fires in your district and seen the effects of it. I remember just 2 years ago where we had those fires down State Highway 50 where we had to close the road for 24 hours, 48 hours. And the only way we were able to save the house was on the other side of the road because they had a swimming pool. So just want you to think about that when we go through these hearings, that water is important to us, as you can imagine, and early access to it and at every premises is vital for our service. Thank you.
Bob, would you like to say a few words?
Yes, thank you for that. I'm Bob Palmer. I'm Senior Advisor Risk Reduction in Hawke's Bay. I do a lot of work with firefighting water supplies, in particular new subdivisions and new builds, and provide advice in regard to the code of practice for firefighting water supplies. It's just like to support what Nigel's saying, and early access to water is hugely important to us. We do respond tankers to a lot of fires in the rural sector. However, we can't totally rely on them being available. They could be somewhere else at the time. So having direct access to water is important to provide protection in case of we need to rescue people from homes or from properties and to prevent spread to other property.
Thank you, Bob.
Mr. Chair, would I be able to ask Bob just to speak to the concept of a defensible space, just given its relevance to the Indigenous biodiversity and so on, just maybe talk to what a defensible space is and why it's important in firefighting terms?
I was about to throw that one to Nigel's way, actually, being in a command, if I could, being he's more in a command role in regard to firefighting. Sorry, Nigel, I handed that one to you.
Nigel, you're on mute again, I think.
Okay, I'm back. Yeah, so defensible space, you would have seen and remember the Port Hill fires are probably the most recent ones over here. 16,000 hectares lost and 9 homes. And that we call that the sort of urban rural interface, where we've got houses built amongst woods and high trees and amongst forests. We really like a sort of 10-meter space around a house that hasn't got and trees that can be planted with plants that don't ignite too well, and then trees that are out of the 10-meter zone to be trimmed down up to sort of 30-meter zone. So we're really looking for a 30-meter zone that's managed around the house and considered when people start planting. That's really relevant for new subdivisions, but also when we're subdividing within an existing plot. The closeness of the trees and the shrubbery is really important to us, and we really can't defend anything less than that sort of 10 meters, because it puts not only us at risk, but obviously the people within the home. So I was fortunate enough to be the incident commander at the Waimarama fire, where the house was lost on top of the hill there, just because of the speed of fire going uphill. So it's really important that when you're building a subdivision on the top of a hill, to understand that fire comes up the hill a lot faster than it does across flat land, and then you combine that with a wind. You can't run fast enough, and quite often we can't move our vehicles fast enough if the wind's blowing in the right direction. So that defendable space is really important. So 30 meters is what we're really after of managed land, 10 meters without any trees. Hope that helps.
I might just open it to the panel to ask any questions they may have.
Yeah, I just have a brief one. We talk about water supply, and it's what are you asking type of water source? Like, are you comfortable with, say, a dam or a river or a stream within a certain distance, or are you just wanting tanks and connected to town supplies?
Yeah, Bob Hammer here. Certainly, if we're in the urban space, we will most probably have reticulated supplies, which guidance here in the Code of Practices within 135 metres of our nearest hydrant. Out in the rural area, we look towards tanks, dams, or bores, but we do need direct access to those so we can get within, say, 5 metres of them to hook in suctions and hoses to those supplies. And then we look for the space of the distance to 90 metres to the building platforms. So and access is a big thing for an appliance to be able to connect up to those water supplies. So, yep, tanks, dams, we even consider swimming pools if people can ensure that these are kept full.
But not streams.
Not stream.
No, that we can't guarantee they will still be there in the summer. Lots of them disappear underground.
Just on the bore one, living by not far from Highway 50, we are watching those fires. Power is a concern about bores. So if you have a bore that you're relying on and the power goes down, is there any options around running them?
Sorry, I didn't quite get that.
Well, bore, like we've got bores, I've got a bore that I rely on. So if the power goes down, are you able to hook generators into them and run them, or is it that's not available?
I've never had the occasion to do that, but however, if the idea is to have our approved fitting on the bore, so we're not reliant on, say, an electric pump to pump it to wherever we need it to be. We can have direct access to the bore through our suction fittings, and then we can actually, draft the water up from the bore.
Yep.
Questions? Okay.
Yep, Kate Taylor here. Just in the absence of alternative water supply in a rural area, and the tankers are being relied on, how much water in a tanker and how long does it take to empty one at full noise?
The most tankers we've got are around 15,000 litres, and depending on how much draw off, it's really the I'm not sure the total time on it, having not been involved with firefighting for a number of years now, but certainly it depends on the draw off on those tankers, how many hoses we have out at the time.
Nigel, answer that at full noise, Nigel?
So it really does depend on what we've got working. And I know that I've had 3 or 4 tankers on rotation, and it depends how far they are from the nearest source. I will reassure the panel that we also have got the use of helicopters, but again, they still need access. So what we're really trying to say at this hearing is early intervention with on-site water is going to be far better than the reliance on tankers and the air attack, which can run into several days and weeks. So what we're advocating here is we have the right water on site immediately, so the first arriving appliances can access it and fight the fire.
I just wanted to preface that by that I have listed in my conflict of interest that I am a firefighter. So I just did want the panel to have some idea of the speed with which, or the need for that water. Thank you, Mr. Chair.
Red. Any questions? Okay, no. Okay, so thank you. We will, as I said, leave you on a without prejudice basis to have those discussions with reporting planner and hopefully come back to us with an agreed set of provisions that we can contemplate. Over the right reply. But thank you very much, and thank you for your patience and flexibility. Much appreciated.
Thank you.
Thank you.
We have
Yeah, please.
Okay, thank you. Can you hear us?
Is this me, is it?
This is you, yeah, you're on screen now.
I beg your pardon. I work from home and I never have any disturbances, and I just had a knock at the door. Sorry, so
Murphy's Law, Murphy's Law.
yeah.
So we've read your submission, but we're happy to hear you talk to it. If you'd like to just to talk to your submission to us, you've got the full panel here with their ears flapping.
Thank you. And I'm just not clear how much time do I have allotted for this?
You're 20 minutes, so 2:35 we're due to take a break.
Very good. I'm sure a well-deserved break. I won't be taking that much time, maybe about half of that, and if there are any questions. So all going well, you may get away a little earlier.
Thank you.
So am I able to,
Yep.
to speak now? Thank you. So my submission is in opposition to the proposed policy in the ONF chapter to recognise the regional, social and economic significance of water storage within ONF 4, i.e. the Makarora Gorge. Translated, this is saying council support the resurrection of the Ruataniwha irrigation dam on the Makarora, which I'm on public record as vehemently opposing. There are many reasons for my opposition, but they're primarily environmental. The cost of water from a dam will necessitate intensive farming on the Ruataniwha plains, and that will be devastating for our local waterways, already under stress. And I'm especially concerned about nitrogen leaching, with local regional council readings showing are already well above safe standards in many parts of the catchment. However, today I'd like to stress the hip pocket implication for ratepayers of this proposed policy. Recent history shows that support inevitably translates into financial support, and that support will come from none other than me and other local ratepayers, and that is of concern. But firstly, I want to pose 5 questions. These are not for the panel to answer, but to consider. And these same questions you would have read in my submission, and I asked for responses from council, but have to date not received any. So I'd just like to run through them now, because it's just not apparent to me upon what basis this policy has been arrived at. So question 1, what is the regional social and economic significance of water storage within this catchment? This is just simply not quantified. We here in Central Hawke's Bay have been hearing this for years. However, it's seldom quantified. I believe that any economic rewards from the dam or a dam on the Makarora River will be unevenly distributed in favour of the large corporate farming ventures who are able to afford the water which most recently is coming in at 30 cents a cubic metre and only going to go up as infrastructure costs increase. The opportunity cost of ploughing money into a dam is never mentioned. Where else could that money be better spent, which might have more evenly distributed economic outcomes for the community? The economic externalities of cleaning up the pollution from an increase in intensive farming are never calculated, never. So repeatedly saying social and economic benefits, like a mantra, simply don't make it so. Question 2, why support water storage within this catchment and not others? This appears to simply be a Trojan horse for monetising the intellectual property and consents for the Ruataniwha Dam. If this council do genuinely believe that water storage is a social and economic panacea, why don't they recognise the potential benefits for water storage in other catchments or on-farm storage? This is why I'm saying that the policy is simply a Trojan horse for resurrecting Ruataniwha as the only game in town. There's been no thought gone into alternative options to address local water issues. I, along with a growing number of locals, would like to see investigation into wise water use. How can we use our existing limited resource more wisely? Some suggestions include changing current unsustainable farming practices. For example, dairy farming east of State Highway 50, which was never a thing when I was growing up around here because it's just not dairy country. And how about looking at clawing back water consents? This is a regional count and falls within the regional council authority, but maybe we need to be looking at clawing back water consents, which currently see 6 large dairy farms allocated 42% of the catchment's total water allocation. Number 3, has any work been done or existing reports referred to by council to quantify the conservation values in the Makarora Gorge and further upstream in the Ruahine Park Conservation Estate? All roads for me lead back to the environment. A water storage in this catchment would have adverse effects on the environment, which clearly haven't been considered as part of this policy proposal. The loss of the Makarora and the 14 hectares of dock land that would be casualties of a dam were quantified by the Supreme Court in their decision to retain the dock land as part of the conservation estate. This is what the Supreme Court found. The conservation land includes Indigenous forest, a unique braided river, and wetlands that would have been destroyed. The area is home to a dozen plants and animals that are classified as threatened or at risk. Council's proposed policy ignores these unique conservation values, which leads to my next question, number 4. Why have Council not included recognition of environmental significance in this proposed policy? There's a clear assertion that there are social and economic values. However, environmental values are conspicuous in their absence. Possibilities for this exclusion might be that there are no environmental benefits or the council don't value the environment, which I'm not asserting at all. I think most councillors do. However, either proposition are unacceptable. Can council confirm that a water storage project in this catchment would be consistent with the Resource Management Act? From the reading I've done, this seems improbable, but I think there's more investigation into the RMA implications required before even considering this policy. I now turn to the hip pocket issue for ratepayers arising from this proposed policy. The track record of chasing the dream of a big irrigation dam on the Makarora has cost ratepayers significantly over the last several years. Hawke's Bay Regional Council, $20 million spent without a sod of earth being turned. In 2019, this council, our district council, attempted to channel $250,000, $250,000 to the private company which holds the consents for the Ruataniwha Dam until thankfully knocked back by ratepayers. In 2020, after saying that they wouldn't channel money to this company, council gifted them $58,000 to cover their annual consent charges. And then just last year, our local lines company, Central Lines, gave $200,000 to a private company looking to resurrect Ruataniwha. Not ratepayers' money in that instance, but again, money being sucked out of the community, which should have come back to locals, in that case, as rebates. I submitted last year, both written and oral, on the council's 2021-31 long-term plan, and implored councillors to not increase rates, which would see my own urban rates here in Waipakarau more than double over the next 10 years from their then $2,800 per annum. They're currently $3,100 per annum, but in 10 years' time, they're going to be up around $6,000 per annum. Supporting a dam on the Makarora River is not core business for council, and I petition council to expunge this policy from the proposed district plan. I further petition council to desist from any further involvement, promotion or pecuniary support for water storage. This is a private sector concern for local agribusiness to address. Beef and lamb schedules, along with dairy payouts, are at historic highs. Support for water storage is within Rabobank's purview, not our council's, and certainly not to have the bill footed by ratepayers. It is not core council business, nor a matter that should consume any more ratepayers' money or resources. Thank you for hearing me out.
Thank you for your well-articulated submission. Are you open to any questions from the panel that they may have?
Certainly, if there are any questions.
Any questions? No.
Dr. Lalib, Loretta Lovell here. Just a question. Noting the NFL policy P5, would you be opposed to a general reference to water storage in another part of the plan?
I mean, without context, it's difficult to answer. Once again, I see it as being within council's purview to invest in water storage for potable water supply for the towns. But to get into that area of water storage for agribusiness, which are private businesses, as I think I've made clear, I see that as being well beyond council's purview. So it would depend on what sort of storage you're suggesting and you know the context around that. I mean, I'm not against water storage per se. If you were to visit my home here in Waipakarau, you would find a very verdant garden, which survives through the summer months on the hand watering. And that's all about water storage. So I understand about water storage, but it just depends, as I say, you know, to what level you're going to take that and who's benefiting.
Thank you.
Questions? No, that was my question, basically. I was going to ask you. So thanks again, and thanks for your flexibility and your well-articulated submission. Much appreciated.
And I appreciate the panel's time. Thank you.
Okay, thank you very much. We'll take a break now for, how long was it? 30 minutes. Come back at 2:55. Thank you. Another swatch from Catherine.
Hi, Brian. Might be
So,
your
so we've got sound working, have we?
Yes, we can hear you. Can you hear us?
Yes, excellent, thank you.
Thank you.
Tomorrow I'll bring you guys.
Yeah, if you
the
could.
play more.
Move the table slightly.
Yeah, I'll have to shift you guys forward a bit.
Over so that we can get in. It would help too, because when I'm spinning around, I'm about to bring into something. 48.
Hang on.
It was in our pile. No, it's in our pile of stuff that came with our agenda. Problem if there's some problem. What do you say? Okay.
Permission.
The agenda. The agenda.
Are we ready?
Yeah.
Okay, I think we're ready now. Good afternoon. The hearing is now reconvened. Thank you very much for your patience. Brian, are you ready to talk to your submission? I will say that we have read your submission. But if you'd like to talk to the key points to it, I'd be very grateful. Thank you.
Hello, and yeah, thank you for having me along. This modern world of Zoom and everything's quite a different world, isn't it?
Sure is.
Sure is. Well, thank you that you have read that. I was hoping I wasn't going to have to read it all to you again. Look, I want to emphasise this peculiarity that we operate under these two different bits of legislation. This navigational safety area under Hawke's Bay Regional Council and activities on the surface of the water. It's a most quaint description, I've got to say, and takes a little bit of wrapping your head around, but for the environmental effects. And as I said there, I'm representing Jet Boating New Zealand. We've got about 2,400 members, about 240 in the lower North Island, and many of them enjoy the magnificent Hawke's Bay rivers. In terms of the effects of Poundcraft on flora and fauna, there's been quite a few studies done. It's very hard to disprove that there's a potential adverse effect. The studies tend to get washed out by floods and all sorts of other curious anomalies. And so there is a dearth of reports that I could table for that very reason. But I do make the point that there haven't been any studies to that effect. 1.4, there's always concern about conflict of use, and my experience with many district councils on the Lower North Island is that is an area that they are interested in. Also remind you there are noise standards. We've run events, number 3, on that Tuki magnificent piece of river, above the Red Bridge, above the bird reserve area. We do run little events up to the confluence with the Waipawa River. That's been done ever since the first district plan was initiated many years ago under that plan, nearly 20 years now. So we have to do a public notice for those. We only hold an event per year. There is a minimum flow on that. Has the support of Fish and Game. And we have 20 to 30 boats on that most years, about 75 people. We often stand at the confluence of the 2 rivers just below Waipawa and have a magnificent little lunch and a good chat together there. It's a pretty good event. Needless to say, lunchtime chat is always about, oh, why can't we go a wee bit further up the river? You can imagine the conversation, can't you? And those have been good days. Look, all we're really doing in our submission is trying to get in place a structure for actually going that little bit further like people have been asking. We can't do that currently because the district plan just doesn't make that feasible. And that's the driver behind the submission that we've put in. So I think the next paragraph is reasonably self-explanatory. And obviously we are seeking for some changes there. Look, I'm going to, there is this discussion about commercial activity, 5.9. That numbering system has changed there, my apologies. The concerns that we always raise as an organisation is that commercial is always far more intense and has much more impact. And we like in district plans to give the council potential to manage that. I'm going to propose over the page on 6.1 how we might do that. So we note that there's been no further submissions to this other than our own one. But having had a chat with our organisation, and you can imagine the challenges with that, we're coming back and saying, hey, look, just for clarity, it is actually the Waipawa section above the confluence with the Tuki that we are interested in, and only up to the State Highway 50 road bridge. So we're suggesting actually, and this is consistent with what we are seeking, is this 6.1.2 is to limit our the activity on this section of water to 3 jet boating New Zealand organised events each year, but with no spawning restrictions as proposed. And part of that is actually further discussions with Fish and Game. They said, well, actually, there's no limit there on angling at any time of the year. The spawning is upstream of State Highway 50, and that they had no concerns about spawning in that section. Not saying there isn't minor low value spawning going on there, but not above there. And that would mean we would delete the commercial use standard that we were proposing, because that would be captured within the 3 jet boating New Zealand organised events each year. And this is a strategy we have used in other parts of the country where the use is limited to just ones run under the auspices of our organisation. That has been working quite well in other parts of the country. So those suggestions would give clarity to the harbour master because even if under the district plan it's a permitted activity or within meeting the conditions of the plan, we still have to go to the harbour master, still has to be a public notice, and that would give clarity to the harbour master on what they could organise. Such a proposal would also limit the anglers' concerns for conflict of use. It would have to be publicised, it would go into the local paper, as we have done on that lower section of the river in previous years. Definitely would limit any potential effects on flora and fauna to what we would say would be less than minor, and it makes that commercial extension irrelevant. Right now, I'm going to throw this back and ask if there's any questions on what I have presented there.
Thank you, Brian. I was just going to do the same thing. Any questions from the panel?
Brian, Tim Aitken here. You want to just go up to the Waipawa, and that, and knowing the Waipawa very well, that certain time of the year it's goes underground for a very long period of the year. Why not the tuk-tuk as well up to the Highway 50 bridge?
Tim, that was just an expediency. We are certainly interested only up to the Highway 50 bridge. Both of them, if you look at all the river flow graphs, to try and organise an event, to run it and promote it as up to 14 days ahead, you kind of need to pick the winter months when there's likely to be a reasonable chance of getting the flow on the day. So certainly we would be interested in that. Just offering it as an option if there are concerns about what I would call the conflict of use issue. Just minimises that effect, that's all.
So in your further submission, you state an early study was inconclusive as to whether a boat travelling in shallow water across a salmon reed may impact survival. Obviously, we don't have salmon in the Waipawa River, but can you name the studies and what impact it would have on trout?
My apologies, I didn't bring that with me. Yes, it was done on the South Island River, obviously because of the salmon. There's been nothing done on trout. Where the assumption is they are similar, but that is a brave assumption. And the reason it was inconclusive is they couldn't prove it, but they didn't complete the study because there was a fresh in the river and it upset the study, unsurprisingly there. So no, sorry, I can't today give you that extra information. As I say though, just to be cautious, we do support exclusion in those high profile areas there, and that's throughout the country. So trout don't spawn in the lower reaches, although they sometimes do. It's very, very low quality. The quality spawning wouldn't be in the headwaters and the side streams where there's low flow, where boats generally are impossible to enter.
Okay. Can I just ask a supplementary? So obviously between the breakwater and the Highway 50 bridge is quite some distance. Is there any sort of preferred place that you're looking at holding these events, or is it just depending on where the river's flowing at the time that you'd be looking to? Is it hard?
Sorry, what was the lower reach you mentioned there?
So you talked about the confluence. So it's obviously is that the Walker Road breakwater you're talking about? Is that where you from the confluence to the Highway 50 bridge?
Correct.
Is quite some distance. Is there a preferred location that you'd be looking to hold your events, or is it all the way up between?
Oh, no, we'd prefer it was that length. That's not a particularly long reach to be travelling up and down there. So we'd prefer to include all of that.
Thank you.
Just a question, just working through the basis for removing the commercial use standard. So are you effectively saying that at 6.1.2, that we limit the events to 3 jet boat NZ events, and that's it? So that therefore there would be no commercial activity. So is that what you're saying?
Yes, effectively, which on this river would never happen anyway, to be frank. The flow isn't adequate for the type of operation they would have.
Okay, so that would also cut out any non-commercial entities as well, should someone suddenly appear.
Correct.
Okay. I guess the next question I had was, you said that there are other councils that have taken this approach, so they haven't referred to commercial, they've just listed the number, say 3 organised events. Can you forward on to Jesse examples of that?
Certainly can, yes.
And also, have you seen other ones where they've simply had the commercial use exclusion?
I'm not sure about that. I will have to check some of the South Island ones. I can respond though with a positive or negative, yes.
Yeah, I guess you'll appreciate that from my perspective, it's always clearer just to say,
yep,
you can't, rather than leaving it to the, well, we're having 3 events and then it's silent. So I'd be interested to see where other council have taken this approach.
Sure.
Thank you.
Just one question. What's the story with other rivers in Hawke's Bay?
The only river that we have, there's 2 rivers in Hawke's Bay, wider. The Nora is our primary one that our members use, and that has a permitted status right up to the confluence of the, I'm going to be caught out here. It is up above Fauna, which you all know, and that's a year-round permitted activity, except for a very small section down where there is a speed restriction under the Harbours Act down by the lagoon. The other river, and that's a magnificent river, and we thoroughly enjoy using that. The other river that we utilise is the Mohaka. Again, it has a permitted activity status right up not far away from the boundary into the dock estate. In fact, is a permitted activity on that river. It's a very rocky river, can only be boated in high flows. A totally different river to the Nororo.
Okay, thank you. Any other questions? No, thank you. Thank you for your very clear submission there, Brian, and well understood. And thank you for your time and flexibility.
Thank you.
Cheers. Mike, thank you for your patience. We were just all grabbing the further submission from Tuki Water Security Project. So we had it in front of us. We have read your submission. Now is your opportunity to talk to that submission and raise any key points you'd like to raise.
Thanks very much. And look, I appreciate the time you've given us today. Maybe I should firstly just expand on the Tuki Water Security Project, because when these submissions closed, we were still in the process of having a report completed and having it released. So apologies for the brevity in the submission, but I'll expand a little bit on that now for your clarity, which would be great. And look, I think I'm currently the chair of the Tuki Water Security Project steering group. We're a group of residents that came together about 2 years ago to look at water security for the region, particularly after these ongoing series of droughts that have been pretty hard hit in the region. We were concerned about communities running out of water as much as anything, and we were focused particularly on the Tuki River, which is one of the main arteries that runs the length of Hawke's Bay nearly. So a very important piece of water and valley for not just the district, but for the people. The purpose of our project was very clear. This has been an environmental project first and foremost, looking to strategically address environment, water and health issues within Hawke's Bay, particularly how we could fast track adaptation to climate change and create jobs. And we had an ambition also of being able to develop the most environmentally friendly water security strategy in New Zealand, a lofty ambition, but one that we think is absolutely possible. We came together and we decided that the whole catchment needed a fresh look from the bottom up, instead of what may have been perceived by others in the Ruataniwha Dam proposal as building a dam and then finding out what to do with the water. We worked our way back up from the bottom of the catchment and looked at the demand and future needs and the climate change trends and how we could find and make sure that the community had sufficient water for future generations. We created a hierarchy of use that we asked our expert advisors to look into that before they did the work. We were very, very clear in that, first of all, we had to meet the expectations and values of Te Mano Te Wai. We then had to look at environmental remediation in the face of climate change, community needs and the health of the people, before looking at higher food value and processing as the final level in that hierarchy of needs. And so Lewis Tucker went away and did their work. They completed that project. We released that in December, and I'll go through the results briefly. Firstly, they looked at 7 different alternatives firstly, they realised that there wasn't enough water even for environmental needs, and we would need to find additional water to meet those first 3 priorities we're talking about before we got onto consumptive uses. They then looked at 7 different ways of securing more water alongside 7 different criteria. And they had a matrix there that where they determined which would be the best possible option. And look, we agree with a number of other people that there is no silver bullet here for water security in the region, but it will take a range of actions if we're going to genuinely achieve water security for the population of Hawke's Bay. They have certainly decided in the report, though, and we support this as a steering group, that the preferred option that does provide a multitude of benefits and provides a key part of the puzzle for water security is the ability to store water in the Makarora Dam site, which is one of the issues under debate and discussion in this plan change. And we would request that the option for being able to store water at that site is retained, because we think it's key to securing water security for the region. Importantly, in that report, we have actually determined that there is a shortfall of water that in the Tuki River, just to meet the minimum flows at the Red Bridge, which is the bridge down behind Havelock North and Tamata Peak, of about 20 million cubes. If we actually looked at being able to store water in the Makarora site, then that could be provided for environmental flows. And that would mean that in every year that we've recorded that the Tuki River flows at the Red Bridge could be met with environmental flows of 20 million cubes. And that was the worst, and that's including the worst year of 2019 where we had the drought. So we think it provides a key piece in the jigsaw to providing water security all the way down the length of Hawke's Bay. I would just note that the Tuki Water Security Report has been supported by a number of other reports out there recently. The Ministry for Primary Industries work around water security and availability that talks about the importance of storing water in peak flow periods and making sure that it's directed to environmental purposes when required. We understand there's a lot of work happening. We're working with the regional council around some of their demand work that they've been doing. And we understand that that is consistent with what we're proposing here as well. Finally, because I want to make sure we've got time for questions, I just thought it'd be important to note that the project steering group is now moving to the next phase. We are working with iwi to try and formalise a partnership with them to make sure that we are fully aligned in our goals and objectives. We are also looking at how we can resolve the issues in the catchment, the Makarora catchment of the dock land, and I won't traverse those issues here because it's not particularly relevant to this clause that we're talking about. But I would reinforce that the project group and the community that we talk with is seriously committed and confident that we can get progress for this region. In that respect, having access to the Makarora site, of which there are consents that are still valid, is a vitally important piece of the jigsaw. I'm happy to leave it there and just take questions and discussion as required.
Okay, thank you, Mike. I'll just turn to the panel, see if there's any questions. I'll come back to you.
Yeah, come back to me.
No, I'm good.
No, I think.
One question. I'm assuming, and I understand that you're talking about policy NFL P5 and the retention of that.
Yes.
It's currently in the section relating to SNAs and etc. Would you have a concern if we moved it to another part of the plan?
I don't understand the implications of that, so that's a level of detail that I'm not sure that of about. So the key thing for us is that when you look at the analysis undertaken by Lewis Tucker, if the dock land is not available, then the project becomes unviable from a cost point of view. So you may be aware that in the old Ruatana for water scheme plans, there was a set of projects that were articulated around environmental remediation, and under this plan, those projects would remain. And so from our perspective, we are looking at options to be able to secure access to the full footprint of the Makarora site. I don't know how that implicates anything from your suggestion.
Well, we are seeking some advice on that at the moment. But as I understand it, you have consents. So
yes,
you have consents, in place, and so I'm not sure about. Robert, you can probably articulate this better. No, as I understand the case law and etc., you have consents in place that there isn't a renegotiation on the basis of a plan review. It would only be if those consents were reviewed or changed in some way. So, given this again, and knowing that you have these pre-existing consents, does that assuage your concerns were we to suggest to put that policy in another section of the plan?
Well, so long as it didn't affect the ability to utilise the consent form, then I assume that wouldn't be a problem. But I would have to seek some advice from people who understand this better than I do.
Fine, thank you.
Yes, and just to follow up on that, the section that Loretta was referring to is a sort of the strategic front end of the plan. And one of those issues is around water resources and rural production and things. And so it's not specific to that project or that consent or that river even. It's a broader sort of recognition of water as an issue for the district. Just to fill you in there rather than ask you a question.
Certainly. Oh, look, and look, maybe it's just worth mentioning, I know that there's been suggestion that having more water available would lead to more intensification. And I think it's important just to reiterate, as a landowner and farmer operating in the Tuki catchment, that I'm operating under Plan Change 6. Plan Change 6, it makes it incredibly difficult to make any changes to intensify. In fact, even the new environmental rules around the essential fresh water reforms also make it incredibly difficult to do any intensification or change in land use to farming practices that would be degrading on the environment. So I think there are a lot of measures in place now where those sort of practices just simply would not be allowed to happen. And I think we can take some satisfaction from that.
Okay, thank you. Any other questions? Okay, thank you very much for your well-articulated submission there. Much appreciated.
Thank you very much.
Ben, you'd like to? Very much for appearing. And thank you very much for the obviously hard work that's gone into your written statement here. Much appreciated. My only concern is that just at my calculation, I'm not talking to the appendix, there's about 40 minutes worth of talking here. Is there any help you can give us in just maybe focusing us on, because it's now part of the record. It's now.
I'll try to go as fast as I can and cover as much ground as possible.
Okay, we'll keep an eye on the time.
Thank you I want to thank the panel for the extra time today.
That's all right.
I appreciate that. This has been a very important issue for us. I'd like to start this morning, just thank you guys for everything you've done. I'm a man of the scripture, so I want to read quickly a scripture and have a quick prayer over you for the long journey, the arduous thing that you're going to do for the community. This comes from Psalms 82. It says, God presides in the great assembly. He renders judgment among the gods. How long will you defend the unjust and show partiality to the wicked? Defend the weak and the fatherless. Uphold the case of the poor and the oppressed. Rescue the weak and the needy. Deliver them from the hand of the wicked. The gods know nothing. They understand nothing. They walk about in darkness. All the foundations of the earth are shaken. But I have said, you are gods. You are all sons of the Most High, but you will die like mere mortals. You will fall like any other ruler. Rise up, O God, judge the earth, for all the nations are your inheritance. So, Father, just thank you for this opportunity to be in front of this panel. Thank you for sending me to the end of the earth and allowing me to speak, God, Lord, in regards to land rights and property ownership and how important this nation is to me, God. These people, God, that are here today, the panel and everyone involved, God, they've got a long journey ahead of them. I pray your peace, your shalom, your blessing over them, their families, get them here and back safe every day until this journey is over. I pray in the name of Yeshua, Jesus of Nazareth. Amen. To the hearing panel and also to the council. We came to New Zealand seeking a society that was at peace within itself from both the government and the people. When we moved here in 2015, the New Zealand government had been voted one of the least corrupt in the world. Having family ancestry back to the American Cherokee Indians, I also appreciate the efforts of the New Zealand government and people to have brought treaty settlements to the Māori for the injustices of previous generations in regards to cultural usurpation and the outright theft of lands from Indigenous. In 1838, U.S. President Andrew Jackson passed a law confiscating the lands of the Cherokee people east of the Mississippi, and he led them out on what became known as the Trail of Tears. But do governments and people really ever learn from the tears of the past? That wrong has never been made right. But in New Zealand, it seemed to be a different righteous path, attempting to right the wrongs of the era of colonization, at least until now. Central Hawke's Bay is very close to making the same historical mistakes that previous colonist governments and are not only set to grab land from Indigenous, but this time from all legal owners. But this is not just happening locally. The buzzword up and down these two islands from the titled landowners is SMAs, SLAs, and all these other designations are governmental land grabs. I'm not the only one saying this, as some members have told me previously. It has become the voice of many of the landowners. But this council willing to listen to the voices that are saying you are stealing our lands, especially when you've invested so much time and resource to come to this moment. Nevertheless, allow me to define this word theft. Wikipedia says it is the taking of another person's property without the person's permission or consent, with the intent to deprive the rightful owner of it. I, for one, do not consent to these designations on my private property and agree with other landowners that this is obviously a modern-day land grab. Once these designations are effectively placed upon the property, they will become a perpetual deeded exclusion to my property that will limit my right of ownership and steal my executive rights thereon and thereof, but not just for me, but for my future prodigy. My children and their children will be restricted from the natural progression of expansion for their families upon these designated areas. Thus, the proposed district plan is not only taken away from us in the present, but it is reaching into the future and stealing from our future generations. Democratic socialism. The current Labor administration has described herself as a democratic socialist. Democratic socialism is simply the process of converting a nation from capitalism into socialism by a democratic process rather than all-out revolution. If socialism is fully implemented, we could see land ownership and the rights thereof fully eroded. It seems difficult to stop this process of socialism when done democratically. Effectively, government socialist leaders simply ask or poll the public if they would like to see privately owned property and businesses become more public via the government process of usurpation. Of course, the public says yes, and socialist leaders make catchy little slogans like "Together we thrive." But what we, the landowners, hear is "Take from me and give to them so you can thrive." I have found it upsetting that our councils even ask the community if they want these designations placed on private lands. Sure, they want it. It's a win for them. Everyone wants something for free. However, no one legally has a right or entitlement to steal land or land rights from others. Neither is it the right of government to play Robin Hood. You have even allowed environmental extremists like bird and trees, forestry, to place a submission. This isn't their land that's being impacted. They don't own it, and it isn't their opinion. And therefore, their opinion is irrelevant as far as these designations are concerned on private lands. This is like asking a thirsty person in hell if they want to drink water. This is, of course they want it. Only the landowners of the named areas of significance have a place to be opinionated therein. No one else has any legal rights or financial interest at stake, or the right to make any submission thereon. CHBDC has treated this proposed plan like it's a poll. This is obviously democratic socialism in all its passive-aggressive effectiveness, polling and enticing the public with the offer of private-owned property. The obvious intention is to capture the property rights via environmental designations from the few and then redistribute for all for the greater public good. I have been very aware of this agenda from day one as you quietly enlisted the most aggressive environmental experts to find any and all lands within our regions that might be significant enough to take away the exclusive private control and convert into restricted areas of named significance. This obviously is the first step to the outright naming and claiming of those areas. Name it and claim it. It is our belief and concern that the naming of these vast areas, vast amounts of lands within our region and upon our farm are a modern day governmental act of land confiscation, not seen since the days of colonization. However, this time the government aggression is not limited to the indigenous only, but to all landowners respectfully. Unlike that time of colonist aggression, we are now experiencing a shift from capitalism into socialism via this passive-aggressive form of democratic socialism. Instead of aggressive bearded colonizers with muskets and cannons, we now are facing environmental aggression that convinces and uses public opinion to take away private ownership of lands or the rights thereof. However, the greater public is said to benefit at our expense. Once these areas are officially named, the government has the exclusive right to determine who or how we can use those areas. Therefore, these named areas of significance will be significantly limited in their usage by us, the landowner. Unlike the laws of eminent domain detailed in your Public Works Act, by using this liberal interpretation of the RMA, local governments can effectively name and claim these lands without compensation due to the landowner. A further benefit for the public and the government is that the landowner who's been stripped of their rights on that named area is still required to pay rates on those lands. Well, it's a win-win for the government, was they will also need to expand in order to manage and police these new government areas of interest, all at the expense of the private landowner. This is the reason the RMA has always been so controversial and why local councils like yourself have been ineffective at renewing district plans. But with the recent events of the last years, there's never been a more opportune time for you to reactivate this aggressive land grabbing measure via the RMA, which is send a self-declared socialist government. And with the backdrop of this global pandemic, private lands stand to be sacrificed for the greater public good without much resistance and possibly no compensation required. This democratic socialist action of naming and claiming private property as significant may seem politically correct, but it is just a democratic means of theft. As Wikipedia defines, the taking of personal property without consent or compensation is theft, regardless of what a poll shows. I see this whole issue like wolf in sheep's clothing. Helen has said that this is supported by her liberal interpretation of the RMA. But the landowner say it is a modern day land grab, plainly stated, theft by a personal liberal interpretation of your RMA by environmental extremism. The vast amounts of areas that you've named proves that this is a very liberal and extreme interpretation and application of your RMA. It seems council has crossed the line from being environmentalist over to environmental extremism and even terrorism. Now, like Andrew Jackson, you could become known, this council could be known as in history as the face of the modern day land grabbing government. It will be hard for landowners to forget the names and the faces of all involved. Like generations past, we may next tell our children that was the day our culture died when they raised the banner, "Together we thrive." Keep out private property. I'm sure you've all seen these signs. At initial glance, you may feel this sign is a bit abrupt or harsh. However, this sign carries the proof that you're living in a free nation where individual citizens can own their own home or property. In fact, a free society is determined by the amount of private ownership which is allowed and even encouraged within. There is no greater instrument of government than to protect and encourage entrepreneurialism of private ownership, from farms to factories. The efficiency of private ownership is unparalleled in performance, profitability, and sustainability. In contrast, the more the country falls into socialism and the less private ownership will be allowed, and government will inefficiently fill that void. When a society is fully enveloped in socialism, the state controls nearly every aspect of the society, inclusive of services, products, religion, and even the media. However, private ownership is usually limited or omitted. Another interesting reality is that the natural resources that you want to preserve of socialist nations are almost always eventually looted. Our local council stands at the verge of setting dangerous precedents with this PDP by allowing and approving a massive shift towards socialism via these significant designations on private property. Instead of working with private owners of these areas of significance, the council is aggressively seeking to sever the right from the private owner via these designations on freehold lands. I've attempted to explain property rights to Helen and to her crew to no avail. I came away realizing that these planners had an insufficient knowledge of property rights and the effect that this PDP proposes on our private property. I do have an extensive understanding via a long history and experience in real estate in several nations, states, and regions. I have personally been a licensed real estate agent professional for over 30 years and been involved in literally thousands of transactions. My son is a licensed broker. He has a real estate brokerage company. He sponsors many other licensed real estate agents. What I'm saying is I am not misinformed about how this PDP negatively affects my property rights and the devaluation that it's going to cause to my property. Our council team apparently needs informing. So I'm attaching a working paper. You can see that how it explains how property rights are defined by the New Zealand Treasury. Effectively, there are 4 types of property: private, common, public, and open access. If you see the chart, notice that the private ownership is distinguished by 4 given rights: access, withdrawal, management, and exclusion. In order for property to fit under the banner of private, it must have these 4 intact. Your significant designations, what I'm calling name it and claim it, propose to take away my management right from the owners, and it will transfer to the state. This has a drastic meaning for all owners thereof. It immediately makes us subservient to government regulation and the interpretation thereof on said lands, since the state would now control the management right. To simply cut a court would require a permit from council, who is now the legal owner of the management right of our property. It is a very tricky way to take away private property, and it's democratic socialism in all its full ugliness. In fact, as the management right is severed, private property actually starts to be identified as common property or even public property. Again, see the charts. This is from your own New Zealand Treasury. Effectively, if council can simply control the management right, then they can decide and determine who can or who cannot even have access to these areas. This in turn takes away 2 other rights: access and exclusion, which I wish I had a little more time, to expand on just property rights. I've got too many other things I want to talk about. In fact, maybe I can request more time later. The potential loss of private property rights in this PDP is very real. I feel that very few people, the planners included, have considered the consequences of these designations on private property. This is that proverbial wolf in the chicken house moment and scenario. You must not proceed with these designations on private property, or at a minimum, push pause until evidence can be shown and known. Actually, my suggestion would be omit all designations and instead offer assistance and empower the landowners while protecting the foundations of our free nation. I strongly believe that much more effectiveness could be seen in these areas of environmental concern if council learned to use the carrot instead of the stick. Simply said, education in place of regulation. But this PDP does the opposite. It steals that right and offers it to the greater public via government control of my management right. But it won't end there. This could be gateway legislation. As soon as these areas are named and claimed officially, and the public becomes more aware of these areas of significance, a new wave of regulation will begin to be discussed to allow public access on these areas. This seems to be a common concern for most of the affected landowners, of which I'm hearing. I'm attaching a recent article from Hawke's Bay Today, Addendum B, of which the Federated Farmers has asked this council to clarify if the public will have access to these newly designated areas. This is obviously a gray area. However, as I've shown you in black and white on Addendum A, how the severing of the management right begins to change private property into common property or even public property. The planners have said this plan does not give public access to the areas at present. However, the public is already licking their lips, and as Addendum B shows, no one really knows for sure. Effectively, council will not and cannot guarantee that public access will not result from these designations. In fact, there is nothing to prevent public access to these areas if council decides, since they hold the management right thereon. Effectively, by taking management right away, they have the right to manage access. So even without the need of future legislation, these designations are already gateways that can allow public access into and through what once was private property. like the old, private property keep out, that could be a relic of the past of a free nation state. So who will pay? If council really believes that these lands are so significant that they need to be protected for the greater public good, then you must be willing to pay the landowner. Otherwise, it's theft. If you go forward with this PDP, these areas will forever be restricted from our use and even from the future of our generations to come on this right of expansion. As a long-term real estate professional and investor, I say this is going to have a huge impact on the subjected land's values. Are you willing to pay for that induced loss of value? I'm attaching an article written by Frank Newman, one of New Zealand's foremost experts on property matters and politics. We'll skip those next 3 paragraphs. In this article, Frank describes this situation our council now faces. It attempts to sever management rights from private property owners. Effectively, Frank is asking the same question: who is going to pay for the loss of these property rights and values? Have the legal landowners been shown negligent or deficient in their stewardship? If not, then someone will have to pay for the loss of the rights and uses thereof. Anything less than compensation for the loss of our rights and land usage would be considered theft. But as your PDP currently stands, no compensation is considered and on these designated areas, although they will be greatly restricted, and still they will require annual rates paid to the council. I also predict council will need to increase their infrastructure in order and increase their rates to keep up with all these new areas they've identified. So now we'll go into 3 laws desecrated. Coming to New Zealand, I found this nation very interesting and unique, and that effectively 2 separate rules of laws are considered by government. As the Treaty of Waitangi was signed, effectively Māori were granted separate governance under said treaty. Like any other nation in the world, both this treaty and English-based laws are now simultaneously established. Therefore, when local or national governments attempt to propose laws or in a PDP, both standards must be honored and legally adhered to. I am not an expert in regards to laws under the treaty. However, I fully respect these to be applicable when looking at this PDP. Having purchased a property that adjoins the local iwi of our region, I have become more aware of the importance of Māori culture and governance under said treaty. Whereas the Māori culture is on rebound and being restored, this PDP is in danger of agitating the old wound from the colonization era. The cold hard reality of a modern day land grab cannot sit well with any land owning iwi. By placing these designations upon iwi land, this council is possibly awakening an old fight and risk discrediting treaty settlement efforts. The last thing we want to see in society is the re-agitation of bad feelings, cultural divisions, and suspicions. Our farm is significant with history of Māori culture sites, and given its shared property lines, we are committed to treaty mandates. Some of these designations within the PDP placed on our farm directly affect our local iwi and stand in defiance of the treaty. I will find it potentially highly hypocritical if this council approves a land grabbing PDP, all while speaking Te Reo at each opening meeting. If this council really wants to show support and solidarity for Māori, honor the treaty and stop the land grab. Councils say these designations upon lands are needed to protect the fauna, but you're actually harming the fauna. These designations will limit any future ability of Māori to expand, use, or enjoy their lands, which is a direct violation of the treaty. A quote from the 87 case says that. Again, the empowerment of the legal owner of the said land is a better option. Education and perhaps compensation instead of regulation is the better way forward. Anything short of that coming out of this PDP would be a flagrant risk to the shaky peace that has been won by treaty settlement efforts. And in my view, it breaks the treaty too. Effectively, New Zealand stands to lose way more ground than this land grab would gain. English law. In 1215, a group of Englishmen converged on the castle of King John, demanding personal rights, inclusive of freehold property rights. The result of that day was the establishment of a list of governing rules that set in order how the people of England were to be governed by their king. The cry of the people became the infamous statement to the oppressive king, every man's home is his castle. The Magna Carta set of rules and standards became the foundational laws within New Zealand colonies. The New Zealand Parliament still recognizes Magna Carta as the foundational set of rules that are absolutely applicable today, many of which are enshrined in the New Zealand Bill of Rights. The Magna Carta of 1297 says, no free man shall be taken or imprisoned or deceased of his freehold, or his liberties, or his customs, or his outlaw, or be outlawed, exiled, or otherwise destroyed. Effectively, Magna Carta gives place to freehold property ownership and further protects those rights from government oppression. Under this standard of English law, no freehold can be taken, nor the liberty thereof. It seems very obvious to me as a long-time owner of land that the kings of our moment need a refresher course on English law. My home, my land, that's my castle. By law, no one has the right to my freehold except me. This PDP seeks to usurp my freehold property rights, my liberties, my custom, and offers it on the public altar of socialism. This is obviously an out-of-control measure by extreme environmentalists in government that are obviously ignorant of the laws of the land. This PDP not only stands in defiance of the Treaty of Waitangi, but also is in flagrant opposition of New Zealand English law under the Magna Carta and the Bill of Rights. But the third law this PDP stands to break for me is possibly the most concerning and dangerous. The law of God. 3,400 years ago, long predating Magna Carta and centuries before the treaty, a set of laws were given to a man named Moses. On a mountaintop called Sinai, the book of Exodus records that the creator of humanity wrote 10 laws on 2 stone tablets that would give governance for all mankind. That set of laws became known as the Mosaic Law or the 10 Commandments and has historically found its place in every nation and people group where the rule of civil law is established. Even enshrined in stone over the top of the Supreme Court of the United States, these laws of Moses have been a guide for people and governments since that historical day on Mount Sinai. Within these 10 simple laws are the statements: you shall not lie, you shall not kill, and you shall not steal. This brings me full circle to where I began. I strongly believe this proposed district plan with its many new designations on freehold land is a modern day governmental land grab. Simply stated, this is theft. Wikipedia defined it as theft. If you don't pay for it, it's theft. If you do it without consent, that's theft. Now, this is where it gets more complex. I believe God sent me here to come and buy this proverbial farm that is set to be the most harmed and to sound this alarm. You might say, I was divinely set up in this way. I reckon God put me here to either be bait in this trap or to wake you up with this slap. Either way, I'm at peace. Please try to open your ear and hear what the Spirit of God is saying. Don't take it away. There is a better way. I'm attaching an article that the Hawke's Bay today said about me when I purchased this property. I've done my very best to care and appreciate this great opportunity granted to me by my deity and to understand the people and the culture of this great nation. I believe I have the experience and the God-given right to speak into this situation. I'm an author that defines God's laws in regard to land rights. So here goes. This plan, with all its new designated areas on private-owned property, is wrong and just simply immoral. I've tried to see the good intentions of the people assigned to create this plan. It's obvious that most have an honest desire to see lands conserved and protected. Whereas this idea is honorable, it does not take into account the issues I've presented. The erosion of private property rights on freehold land is extremely more dangerous to this society than any environmental issue. There is obviously more at play here than just the environment and the conservation of resources. There is another agenda here at work that aims to destroy the foundations of New Zealand's freedoms and replace them with socialism. When treaties and laws are broken, bad events follow. but theft under the laws of Moses brings even more dire consequences. A prophet named Zechariah was shown what to expect when this ancient standard is disregarded. Zechariah 5:3, this is the curse for everyone that steals. They will be cut off, and the curse will enter into the house of the thief, and it will consume the timbers and the stones thereof. There becomes a very personal accountability under the Mosaic law. God only can judge both the affected and the connected. My greatest responsibility to him is to sound this warning. I believe that's why I'm here today. Unlike the Treaty of Waitangi and the English-based laws of New Zealand, these higher laws have a very predictable outcome if broken. They are written in stone, they are not flexible, and will call accountability on all levels. I pray for each of you to try to hear the concerns of this nation, for this region, and the curse that this land grab, the curse that land grabs have caused, and the curse that another land grab could cause. Please consider these things that I've said. This cause and effect before you neglect these laws, the treaty, and God's law. Before you make a decision on these designations on freehold property, just because you have an opportunity does not mean this is the right or the moral thing to do. But there is a better way. As a landowner, I am not in opposition to making better our environment or protecting the resources thereof on our freehold. I believe most owners are keen to do the right thing. Most owners are already engaged in great resource protecting schemes, of which this plan neglects to admonish. The PDP effectively punishes these personal efforts and snatches the land out of our hands in oppression. I personally am more willing to listen and respect advice regarding these areas that you believe is significant and how I can better protect the resources thereon for my future use and enjoyment. A win-win scenario can be achieved that leaves all freehold rights in place without a name it and claim it designation that would forever sever these areas from privatization. We alone are the stewards of our land and on our lands, but we would welcome assistance. Unlike governments, we can efficiently achieve much better outcomes than you can. Perhaps we could become willing volunteers in such a worthy task, but we are not willing to surrender our property rights. If all the money council had already spent on this issue had been allotted to preservation work, think of the good that could have been achieved. Why not work with us instead of against us? Why not use education instead of this regulation? Other councils are doing this thing. This is a viable option for this council. I'm attaching a recent article from the Far North District Council for your consideration that confirms an option of pushing pause on these land designations within the PDP. Perhaps the PDP can go ahead and proceed if these designations are removed. But so far, the council isn't listening. We simply don't want the designations. Perhaps this hearing will hear us. The landowners stand to lose so much. And perhaps you will recommend to our council to make different inroads in and achieve the same ends. An alliance could be formed where council respects property rights and property owners respect the aspirations of the council and the greater public interest. But we cannot be quietly railroaded into a state of socialism where we surrender our property rights over to be commingled into the greater community at our expense. Please do not allow council to proceed and become the latest and greatest land grabbing government of our times. Remember, the indigenous flora and fauna are important, but the fauna and the families are too. That's my family you're taking from. My children in the future, the fauna's children in the future. If you go through with this, man, this land is forever severed from us. We won't be able to fully use it. We'll have to pay the rates. We'll have to do everything else on it. And then the greatest risk of this is that the public is going to see it and want it. And it's going to be forever stolen from us. I mean, this is not the way forward. You can do that on common land. You can do that on public land. But if you take away personal property rights from an individual, you are eroding the very foundation of this nation. Don't do that. This nation's great, man. I came here seeking the greatness of this nation, what you guys have achieved, where you've got along, the way different people groups have acknowledged their wrongs of the past and have come together and created a nation, a culture, a people. It's been amazing to watch. Don't risk it.
Okay, thank you, Mr. Zen. I just quickly would just have a look at your addendums. If there's been any change on that side. Thank you for that. And thank you for all the effort you've put into this articulated submission. I might just turn to my panel and see if there's any questions for you.
No, I think it's all covered. This one, I stand to be corrected, but I believe you have an existing SNA on your property on the operative district plan. Yes. What hassles has that been, or how has that affected your ownership or management today?
Well, as a real estate investor and long-term licensed agent, I saw that on the LIM. I mean, when you're buying a piece of property, the first thing you do is say, bring me the deed. Is there any easements to it or through it? That's the first thing a real estate investor will tell you. How do you get to the property? Do other people allowed to go through it? Because if it's private and people are allowed to go through it, why am I paying for it? I'll just be one of the members of the public and I'll go use it like they do. And I won't have to pay for it. Pay the rates, pay the upkeep. When you're buying personal private property, that's what you're buying, privacy, the right to exclude others. So when I looked at that property and I saw that, there was 4 hectares or something identified in the 91 legislation, RMA. All right, I said, okay, this is forever a part of the deed. I understand that. Do I want to buy it? I think I will still buy it. It was only 4 hectares. What you're proposing to do on my farm now severs the whole coastline from me. As a real estate investor, as an understanding of value, I just lost. I bought that farm because of the coast. I came up there, they showed me the rest of it, the farm. I was like, I'd be crazy to buy that farm. But then they took me to the coast and I said, oh my gosh, look at this. This is a gem. This is absolutely beautiful. This is worth every penny they're asking right here. And you guys are offering to just sever it from me. You're not even going to compensate me. You're going to forever limit my ability on it. I can't subdivide it. I can't cut a gorse. I can't even use it properly. But here's the danger, man. Here's the danger for me and my wife. We're like, then everyone in town's going to say, hey, there is some beautiful property out there at Caracal. You know, we get it a lot already, people wanting access, and, you know, we give access when we want to the right people.
Thank you. You've answered my question.
Yeah.
Thank you.
Do you have any view on the QE2 covenants?
Yeah, I think they're great. Yeah. I mean, if the landowner chooses to take his land and conserve it, and they want to do that, that's their right. See, they still have that right intact. They get to choose. That's the beauty of owning a piece of property. You get the right of management. That's what that chart shows. I would really encourage you to look at that chart. This is written by the New Zealand Treasury. They are, and isn't that ironic? Because landowners stand to lose so much. So the Treasury is identifying what private property is and what private property isn't. Private property isn't public access, or it wouldn't be private property anymore, would it? You take the banner away and you erase it and you say, well, okay, right, if the public can come, if other people can use it, then that's common property. That's the label of that under that chart. But private property means just that. That's why I put that in this, that sign, private property. Keep out. You can say that when you own land. That's the beauty of it. You can't say that in a park. That a park is public property. You can't say that on common property. This is likely common. This ground we're here is common. I can come up here if I want to. You can come up here if you want to.
Okay, you've made your point on that.
I'm quite passionate about these issues.
I can't miss that. Last question I had is, I'm just looking at the public spaces section, and it talks about access to public access coastal property, as you're talking about, and it talks about negotiating with landowners.
Which act does?
This is the PDP, and in terms of public access, and you're making about public access in general. And it talks about directly negotiating with landowners. So not coming on in, as you comment, but negotiating with landowners.
Who would negotiate with us?
Well, in this instance, it would be the council, but they would be negotiating with landowners. Is that not a good thing?
Are you asking to purchase my access? Is that what you're asking?
I don't know. I'm just saying that there isn't the absolute assumption that they're just going to come in and take, as you commented. I'm just noting that there is a rule here about advocacy and liaison with landowners. Is that not a good thing?
No, I mean, I think as a landowner, when I own all four rights, I own the management right, I own the access right, I own the exclusion right, and I own the withdrawal right. What do these mean? It means I get to manage it myself. I get to decide.
I get your point.
Yeah.
I don't think.
So you're asking me.
I'm not going to get much further on this. It's okay.
Yeah.
It's fine. Thank you.
Okay. Well, thank you, and thank you for your time.
Absolutely. Thank you guys
for the effort put into your submission.
Absolutely. I
appreciate
Great
it.
blessings on you guys for the journey ahead. May you be at peace and be protected from sickness and all this stuff we're in.
Okay, thank you very much. Time's 4:08. I think this is where we can go back to continuing our conversation around the Section 42A reports. We had a little bit of discussion over afternoon tea about that. So I'm sure that's prompted a few more questions. I'm not quite sure how to start. Where did we leave discussion this morning?
I was just whether you had finished questions from Stella, and if you have,
Because I took up most of the time.
Which member of the panel would like to ask the question first?
With Stella
Yeah.
on the public open spaces.
So obviously the RMA requires us to protect areas of significant Indigenous vegetation and significant habitats of Indigenous fauna. And the NPS Indigenous Biodiversity is it asking us to recognise significant natural areas? Is that correct? Or the draft? How does that relate?
So the term SNAs is definitely a Indigenous biodiversity term. I'd have to go back and let's check how they overlap. Yeah.
So if the draft NPS, because nobody seems to really know the time frame for that, if we push ahead with the NPS IB in reference to it in our PDP, is there any, I'm not sure, any implications if it, if it, for some reason it's put on hold for the foreseeable and we're referring to it or using the terminology in our PDP? Is that an issue? Do we see?
I think how we've tried to draft the section is to really reflect the requirements of Section 6C. In terms of the NPSIB, you've tried to align it, but I don't think that's out of with where other district plans have gone in terms of their provisions either. I don't know if that's any help or not. But I guess if you're asking me would it stand on its own without the draft NPSIB, then my answer would be yes, that it would stand on its own and that the justification for doing it is there irrespective of the NPSIB.
Talking about SNAs and that, and I think we've just heard a very passionate letter on it. One of the biggest concerns I've heard from the community from a number of people is over the time I've been working on this plan, and that's right from the go, is that they're concerned that yes, why we recognise those significant natural areas now, and there's no actual restriction on what they can do. They're concerned that at a later date a government or a council is going to come along and take it from them or put more restrictions on it and that. And the question I sort of have is to try and mitigate against that, or to give some comfort for those landowners, is there any way we can put into the plan some wording or something that in the effect that says, yes, we've recognised them, but we also recognise they're still privately owned land, and it is owned by the private landowner and no one else. Or effective something like that. I'm not a lawyer, so I don't know the proper wording, but anyway.
We have tried to do that. Like we've acknowledged the fact that the rural and I mean that for rural landowners that they're the ones who bear the burden of it, right? Because all the SNAs are in the rural area, so we've acknowledged that in sort of the text that sits around it. We've also, the framework that we've tried to put up in the rural framework is to allow that stuff that happens legitimately, legitimate farming activities that they're still enabled. You'll probably be aware that there's a number of submissions on fencing, and there's basically the forestry organisations are pushing to have fencing requirements, and federated farmers are saying, well, we actually want you to state in there that you won't have fencing requirements. And we've kind of sat in the middle. We haven't put any wording in there about fencing requirements. And that's been from a very clear community sort of, well, the farmer response around that. And there is no requirement to fence these areas at this stage. I guess we can't make a promise on something we don't know in the future what's going to happen, because if a national policy statement that comes in, for example, and said you have to fence, and actually even the draft NPSIB doesn't do that, but if it did, well then you're kind of stuck because you have to give effect to it. So we could make that promise in the district plan, but it's a pretty hollow promise, and I wouldn't personally, it's not something I would promise. I would recommend promising, but yeah.
Yeah. I've got another one that's slightly different. The Makarora Gorge, when we were doing the district plan, we did talk about that, and I think we got a legal opinion around the consent sitting over that. Is there any chance that this committee can see it, the commissioners can see that legal opinion?
I've sent that through to our administrator for distribution. Yeah, can you just confirm the one thought I had in terms of a legal opinion is, of course, once it comes to us, then, you know, from a fairness point of view, it would be very likely to become public. So you may want to just double check internally about whether that would be appropriate, provided for a particular reason. If we can't actually have the opinion, you may be able to summarise it for us in some way or something in terms of your report. That would be a definitive way. I wouldn't want one of my colleagues to come back to me and say, oh, didn't intend it for that. They might have put it in a different way.
Just another question relating to SNAs. There are, is there 6 or 7 criteria And I think there's an amendment recommended that you've got to, well, if you meet one, you've got to, criterion one, you've got to meet at least one other. Have we got any SNAs that currently only meet one? Are we aware of?
Oh, that'd probably be a better question for Jerry.
Yes.
Yeah.
One question, having heard my conversation with Mr. Zant, and that I put them around policy PA M3, and that was one about open spaces and negotiating with landowners. Would you consider that deals with his obvious issue in his submission about public access to his land or to the coast of his land, but ultimately such access would be subject to that policy of negotiation, or am I getting that wrong?
Can I just, what policy or what?
Sorry, it's
PAM3.
PAM3 in your open.
Oh, in the open spaces
one. You edited it, and that's why I was looking at it, actually, the only reason I saw it, to inform about public locations and things like that. But the synopsis of it would be you negotiating with, directly negotiating with landowners. I'm just wondering if that is remotely of relevance to Mr. Zant.
I think public, if I can answer.
Because it was just.
I just think public access is just not one of his worries.
I know, but it would be nice to be able to articulate somewhere in the decision that we have considered something and been able to articulate it in this way. It won't cover all his issues, obviously, but it was just a thought. So I just thought I'd ask you if I'm not going, because I wasn't thinking about this policy when I was previously looking, it was a bit off the cuff.
And I think that amendment is in response to Federated Farmers submission, because they're quite mindful of public access issue being an issue. And so we're wanting a slightly stronger advocacy education role.
That's good. I mean, like I said, sometimes all you have to do is just at least provide something to say that there's an acknowledgement. It won't be the whole in any way, shape or form, God willing, but it will.
I guess I would say with the SNAs, that's not about public access.
No, but I don't, I
appreciate that.
Yeah, which is why I just wanted to ask you, because it was a bit off the cuff. I wasn't sure if I was connecting the dots right.
A question regarding the recreation on the top of the water or permits. The jet boating, is it normal to allow or to specify just one organisation to be able to have events?
I think is it
to detail just one organisation in a district plan?
I think you might talk more about the type of activity rather than the specific organisation. Okay. So I've had a quick look at Hastings district plan, and they've got some rules that look a little bit like the framework, and he may send that through as an example, where they talk about recreational boating, I think, activities allowing for a certain number of events a year rather than a specific.
Yeah. So I'm just wondering whether, if recreational boating could mean that you could have a number of boats any time during that period, wouldn't you? Like just anybody. Boat.
Well, they do in Hastings, don't they? Whatever, pick you up whenever they like.
So they talk about commercialised, non-commercialised motorised water recreation activities, and then they've got some standards limiting that in terms of numbers of events, times of year, hours of operation, etc. So that's how they do it. Yeah.
Do you have a perspective on excluding commit? Oh no, I think from your report, your response to the jet boating submission was to, to reference non-commercial, non-commercial. What's your perspective on the alternative suggestion that he's made in terms of?
I mean, I guess it's kind of understanding what the effects are that we're dealing with, and because this isn't a matter that's had any other than the jet boating New Zealand, and I didn't necessarily fully understand his submission, and it was really useful hearing what he had to say today. So my perspective is that, yeah, maybe there's some room to move there, but I just need a little bit more time to think about it. I guess picking up perhaps on, I don't know whether it was Kate or Pip asked about the studies that he's referring to and understanding, if there are effects or not effects. Yeah. So I think it might require just a little bit of thought, but I certainly think that there may be some option to move there. Yeah.
I didn't. I was actually quite comfortable with you saying no commercialised, because at least it was clear.
Yeah.
Leaving it to silence just seemed a bit.
Yeah. To say, yeah.
I also,
and again, I think there's probably some other words that we can use if it's.
Yeah. I also wondered about their specific entity, three events. Well, I don't know if there are alternatives, but of course this is potentially a 10-year plan. Are we going to align it with a sole entity for the entirety of those 10 years, as opposed to 3 non-commercialised events? And
yeah, I think my preference would be to align it to the activity rather than an organisation.
Yeah, thank you.
I mean, according to him, there's not a lot of information on the effects, which is a difficulty, isn't it?
Yeah, and we don't have any either.
Which is probably why taking the precaution of 3, well, is it 3, is it 1, is it 2? Where is the comfort zone in terms of things? So it would be helpful to know what other councils are doing, at least in terms of the number that they're proposing.
So Hastings, for example, and we're quite, and I'm not saying that theirs is right, but they talk about non-commercialised motorised activity, and they talk about passive and non-motorised water recreation activities, and then they talk about non-commercial motorised water recreation activities, and they have up to 3 temporary events a year, and then they state the area of river that it's limited to.
One, I'm unsure of how this sentence is going to end at the moment. Several places in the section 42s and other documents, we've talked about how the mapping system has been less than perfect, and I'm concerned that the ground truthing is being put back on the landowners. There was also comments from Mr. Zant and perhaps Mr. Lever about the cost of this, of the whole SNA process being put back on ratepayers. What's my question? Have we, I've lost my question. I had it in my mind as when I started all of that. Have we got the onus in the right place for this ground truthing?
So I think what helped me in kind of putting this in some perspective for me, whether it's right or wrong, it's for you guys to sort out. But the SNAs are not new. They have been there there's been a form of SNA there forever, or for the last 20 years. And in fact, the current SNAs are much broader than the than the proposed ones. And Jerry will be able to explain that a little bit more. So, but for example, the former ASC&B is based on the DOC's recommended area for protection. So these quite big areas, whereas Jerry, through the process that he's used, he started with those, and then he's applied all the information that he could through all the various databases that were available, plus local knowledge. I mean, John Chain, who's the local wildlife specialist, has been out on a lot of the sites. Jerry's visited a number of the sites. And so what they've done is they've kind of applied another lens over the top of those that's applied the most current information. So what that's meant is you've ended up with what might have been one former area. It's now split up into 3 or 4 areas. So it catches the key bits that appear from all that data to be Indigenous areas, significant areas. So a lot of the other areas have kind of dropped away. So what it's meant is we've got a whole lot more sites, but my understanding is that it's not necessarily broader than what was already there. But again, Jerry can clarify that. So that would be the first thing. The second thing is that the rule framework that applies in the current plan is really restrictive. And actually it's never been applied. So whether that's because no one's just really known about them and just done stuff, and now people will be aware of it. So whether there's going to be a whole rush of applications, or whether it's, and I suspect it's a bit of both, whether it's a reflection of the fact that a lot of these areas are actually, because it's only the stuff that's left, right? So what Jerry said in his reports is that something like 90, 89, 90, whatever the percentage is of Indigenous vegetation's been cleared, it's gone. So we've got this little bit left. So we do have to really look at how we're looking after it. And the reason that it's left is pretty much because it's in those areas that no one's really wanted to use for anything else. And again, that's a very simplified way of explaining it, but it's those deep inside river valleys, it's on the coast. So it's kind of those areas that don't have a lot of, I guess, value for rural farming, or they're areas that the landowner has sought to protect. So getting back to your question, which was about the ground truthing, and the cost and where it falls is council had to make a decision, a really pragmatic decision about how to do this. I mean, yes, it does put a cost on the landowner, but I guess what I was trying to get at is how often there might be a consent application. I suspect there's not going to be a rush of consent applications versus spending, because council's actually already spent a significant amount on doing the work that they've done. And to ground truth all of those would have been a huge cost across the whole of the district. So it would have ended up falling on all the landowners anyway. So it is just balancing that. And again, hopefully Jerry can give a little bit more sense for you around what that looks like. So I guess in my mind, I got to a level of comfort of going, okay, yes, we haven't ground truthed every single property. We did do some quite significant consultation. We had how many rounds of landowner meetings?
3 and 2 rounds of meetings.
3, so we had a number of landowner meetings around the district. They were held at several of the halls and they were really well attended. At those meetings, both John Hudson, who did the landscape assessment, and Jerry Kessels, who did the SNA assessment or natural heritage assessment, were both there. They were there and they talked to anyone that wanted to talk to them, and went looked at their land, went down and looked at it, and then in response to invitations from the landowners, that's where the ground truthing is at. And then we went through the draft plan process where submissions came in and people came and submitted. And again, there was another opportunity to go out and do ground truthing. So that's kind of, so it has been through a pretty robust process in that sense.
The other side of it was the cost after, on the other side, we've hardly had any resource consents for the current SNAs under the operative district plan. How much, what's it likely to cost council, or what's the likely onus on council to have to continue the policing of the new SNAs?
The cost of policing it?
Enforcement.
Enforcement. Yeah. And there's other provisions in the plan as well, which you'll come across later when we get to the subdivision section, that actually give a reward for protecting those areas. Yeah. So you can, if you put aside areas for protection, then you can, or are protecting an area and you wish to subdivide, then you get an additional right of subdivision that's not otherwise available. So the district plans tried to sort of add some incentives as well as doing that. Oh gosh, you've got this area that now has some rules around it, and the rules are around vegetation clearance. Trimming and clearance. Yeah, so that's what they relate to.
Yeah, it also affects fences and bridges and slips, and
there is some
fire breaks.
There is some leeway for that where it's around existing ones, but new ones potentially could have significant effects. So it was felt that it was appropriate to run those through a resource consent process. Yeah.
Question, just following on Kate's point. So under the existing plan, I think, as I understand it, you're saying that there haven't been many applications, probably because most people don't know that they actually have to apply or don't apply. Would that be your sense? Or
they're not cutting them down.
They're not cutting them down.
Yeah.
So I guess one of the things that we have to consider as part of this process is, of course, assessing the efficiency and effectiveness of the provisions that we're providing. If we're creating plans or policies, etc., that are just going to be ignored, eventually, how is that effective and efficient?
Well, we don't really. I probably couldn't comment on that. That's a resourcing matter for council in terms of their monitoring and enforcement going forward. I guess the other thing I would say about the rules is, again, we've tried to write them in a way that recognises that these sites aren't ground truthed and that it's not perfect. So we've tried to provide a pathway through that where you land, like I think for the Mānuka and Kānuka, it's a restricted discretionary activity. So, and then there's matters for assessment. So that process is potentially not so arduous, and try to sort of navigate a way through that does address the fact that this isn't a perfect world that we're working with. So Helen's just made the point that the existing rules are actually tucked in the rural zone as well as a standard. They're not actually even a rule. They're sort of sitting in there. You go through and they're kind of a standard that you kind of go, oh, that was there. So
how do they apply if they're not a rule?
I think they're a rule. They're a standard, yeah. But yeah, I mean, I guess what I'm saying is you don't look through you don't go through to the rural zone and go, oh, that's a permitted activity, that's a permitted activity. It's not till you go to the standards. So if you're doing, I don't know, farming, and you go subject to standards, and then you go to the standard and you go, oh, actually, I'm clearing some vegetation, and then you hit that standard over there. They're not really obvious. They are tucked.
Maybe one reason why they're not really seem to be working. Maybe more a question for Jerry, but has there been any sense of what's happened in the remnant forest areas over the last 10, 20 years? Increased, decreased? I'd just be interested. I know his report really didn't cover that. He's spotted differences in methodologies and things like that, but he didn't really, there's no real sense whether the district's actually been gaining because there's been a lot of regrowth or losing because there's been a lot of.
He possibly will be able to talk to that. I think it did go up a little bit in terms of the areas that he's identified in terms of actual areas, square metres or the hectareage. But that might be, again, that might be more because of the mapping, the more detailed mapping that he's done, as opposed to the fact that it's, I don't know. And he may not be able to tell you that because the baseline is not that good.
The other thing too, was there any consideration given to, and I can't remember which submitter or submitters raised this, but using QE2 covenants as an incentive, i.e. if you have got one that ticks a certain criteria and whatever, then it's excluded from the rules.
Well, there is. If you look at Eco Rule 3 in the draft plan.
What's it again?
Eco Rule.
Page.
So I'm just.
No, there's no numbers. So what was it? Eco.
So if you go to the Eco and Indigenous Biodiversity chapter, if you go to the rules, if you go to Eco Rule 3, and it talks about trimming the clearance of Indigenous vegetation inside any area of da-di-da-di-da, which is essentially inside an SNA. And you go down to, it's permitted if you're either A or B. And if you go down to B3, if it's carried out in accordance with a registered protective covenant under the Reserves Act, Conservation Act, Queen Elizabeth II National Trust Act, or the Reserve Management Plan approved under the Reserved Act, it's permitted.
But that's just relating, no, that's total clearance. Could be total clearance.
If it's in line with.
If it's in line with their covenant or whatever, which is probably unlikely they could do total clearance.
UNP covenant? So I would be interested to.
Good question. My understanding is that they're more strict. They're quite strict in terms of what you can and can't do. Yeah.
Clarification. Yeah. Interesting example.
I mean, no clearing.
So it is certainly the intention of these rules that if you have any of those other statutory limitations on your site, then we're recognising that it's an SNA. However, if you're doing it in accordance with those other things, then the district plan doesn't want to go there.
First time I've heard that. Not in line with those, the district plan.
Yeah.
No, it is in one of the reports, I think, subsequent. And I think the intent from the desire from the submitters was just
exclude it full
to
stop.
exclude it full stop.
Definitely federated farmers want to exclude.
They want to exclude, and this was the
Don't want them
alternative.
there at all.
Which would make it a permitted activity, but would still keep it in the plan.
Lots of things to think about. I'm just wondering, what's the time? 4:40. How best to do this? So tomorrow we'll have Jerry and John available online. Rowena, we really haven't gone into your report yet. Do we? Yeah, exactly. Do we want to start some questions for Rowena now, or?
Walk through my.
No? It's been a long first day.
Come in at 8:30 tomorrow.
Oh, we do have, we do have much of the afternoon. I don't think it's been all afternoon. As long as that fits in with you and Jerry and John.
We've got Monroe's coming this 2:15.
2:15, that's right.
John and Jerry would be after. And depending on whether the panel had any questions before I close.
And how long is this?
Taking the stand in 15 minutes, right?
Okay, well, with that in mind, unless there's any contrary votes, I might adjourn the hearing for the day and we'll resume at 9 o'clock tomorrow morning. Okay. Jesse, has there been any changes in the agenda for tomorrow, or apart from what Alan just mentioned?
I'm talking for Clarkson to confirm it. They were happy with 1:30.
Okay.
I'll have to give them a. They have confirmed. They have.
So we'll adjourn the hearing for today.
Okay.
We leave.
Maybe